Your Lordship, in respect of item number 35 and 36, Lordship, we are withdrawing our names from the we are withdrawing our names from both the cases, Lordship. We'll file appropriate applications on Monday.
Well, this is the matter that we mentioned, my lord. My lord,
No. If there is an interim order, we'll vacate it. Don't worry.
my lord, that my lord, the petitioner, this is the third or fourth set of counsel they are, my lord, changing, my lord. Initially, Mr.
Don't worry. Don't worry.
My lord, there is a partial interim order.
No
Because of that,
adjournment.
we are unable to go ahead, my lord.
No adjournment. No adjournment. Mathis.
Lordship,
Mr. Dhar, this type of practice is goes on in Sikkim. Whenever the client, the counsel finds it difficult, it is always mentioned that I'm withdrawing it at the course of hearing. That is a practice which is not, this is not here in Gauhati. Yes. Next.
Item number 1 on behalf of SB Lashkar, Your Lordship.
Huh?
Item number 1, Your Lordship. Motion,
Ah.
today he is out of station, Your Lordship. As per his instruction, I am mentioning this matter for adjournment.
What is the matter about?
Well, this matter pertains to settlement of issuance of NIT matter for settlement of cattle market. In our case, Lordship has
Yeah, PNRD, what remains in this? Tomorrow, with another 15 days.
At least for
15 days is left. We'll see when the matter reaches.
actually today he is out of station, Your Lordship.
You get hold of the file.
please, Your Lordship. Lordship, in item number 49, Lordship, we filed a affidavit in opposition yesterday. Lordship, may allow me to call for it.
Lordship, I did to mention for listing also new cases Lordship, on Monday.
Friday. Next. Monday.
Monday. Yes.
item number 2.
This has become infructuous. They will do it. Where is the PNRD council? No PNRD council? And what is your case?
Mine, my lord, we have paid for issuance of NIT matter.
They will do it whenever it is. Now, obviously, we can't allow them to issue. We don't. NIT issuance is 15 days.
Yes.
15 days notice,
Yes,
isn't it?
Yes, ma'am.
So if it is a 15 days notice, the period is over. For this period of 2025-26, it is not possible.
Exactly, madam.
So you have to come again after the year comes in. I will pass an order. They will do it. Where is the other side?
My Lordship,
This matter should have been disposed of then only. I took up the matter earnestly.
yes, 6408 Lordship has taken, my lord, as part of Lordship's order, an affidavit was also filed, my lord, by the respondent PNRD, my lord.
What do they say?
They say that, my lord, representations there could not find in their records, my lord. That affidavit has been filed by video, my
It's
lord.
okay. Now these, Mr. PNRD, you are going to do it for next coming year. Now to obviously the period has become infructuous for them.
Well, some boundary disputes are there. That is why that was NIT was not issued.
So if the boundary disputes are resolved,
Yes,
then
yes,
we will do it.
yes, yes, ma'am.
So that is it. So these repetitions, we can't pass an order today because this is
Going
for
to
the
be-
period 2025-26.
My lord.
If they don't do so, then you can again approach the court. Okay?
But only with regard to the dispute, my lord, which has stated the boundary dispute, my lord. All along, my lord, in that particular, my lord's area, the respondent, my lord, has issued the NIT on earlier occasion, my lord. Now they have come up that there is a boundary dispute, which we do not know, my lord. Only a statement is there, no complaint or anything, my lord, that sort. So that lordship will kindly take it to consideration, my lord.
We will say that they will resolve the boundary dispute and go ahead with the tender process, because if they don't do it,
Yes.
The PNRD is very rich, I suppose, no?
No, my lord.
Yeah.
No.
Then why you are not, why don't you want money?
My
Or
lord.
is it, or are you doing something for the benefit of some private?
No, my lord.
Very.
Not at all. That is not.
Mr. Counsel,
My lord,
it seems for some private ferry.
No, my lord.
no, private, I don't have that instruction, but my lord, in
There
the
are links to
other
this,
Now,
market,
why are they not doing it?
now, my lord, we have come to know that there is a boundary dispute, although, my lord, we do not have any kind of.
Anyway, so let us first take up the first item.
Yes,
My lord,
Wait, who is appearing for first item?
Mr. SB, an adjournment there was made on behalf of.
Now it has become infructuous. Settlement of cattle market like CLTech Bazaar. Same. Both are
same.
Same.
Okay. Who is that counsel who was mentioning it? Any person
Mr.
out there?
Mr.
Okay.
K. Mida,
my lord, lordship may kindly see paragraph 4, man.
Up here.
The reason, man. Yes. Running page 25.
You know 55. In
Yes,
which
25.
25.
Paragraph 4, may I read, my lord? It may be mentioned that there is no record in the office of
That's
the.
okay, no representation, I'm not on.
Yes,
that.
yes, yes.
My question is,
Thereafter, madam, from record available in the office of the block development officer, it is seen that an order so and so dated 7 August 99 passed by ADC Kasar Silsar for shifting the CLTech cattle market from Nice Pulbari Part 1 to Trinapur so and so so and so. However, the said order was stayed by the Honorable Gauhati High Court, while order dated
But it
1
was
10
vacated.
99. Subsequently, the stay order was vacated by the Honorable Court in order that so and so. In this case, it may be further mentioned that the present site location is CLTech market. It has a long dispute boundary issue, as there was no specific area mentioned for the plot. Moreover, no deed of registration donating the instant land could be traced. This is the main thing.
My lord, may I request lordship permission to peruse page number 30, my lord, which they have annexed in their affidavit. Annexer A, my lord, that order 1999 order, my lord. There the deed number, registered deed number 1234 is mentioned, my lord. Donating the land. That is the type document.
anyway, they will resolve it.
Yes, yes.
Because after all, it is the question of the public exchequer.
My lord.
Yes.
Both the petitions have been filed, are filed by the person, by the petitioner being aggrieved. By the actions on the part of the respondent PNRD department. PNRD. In not calling for tenders for settlement of the CLTech cattle market. It is relevant to observe that when these petitions have been filed, were filed, were for the year 2025-26, which ends on 30/6/2026. A perusal of the Assam Panchayat Act 1994 shows that, and more particularly, Section 105
105, my lord.
empowers the Panchayat institutions to settle markets, and on the basis of such settlement, the Panchayat institutions run out of the money derived therefrom. This court have also taken note of the affidavit filed in WPC number 6408/2025, wherein the PNRD department have stated that on account of certain disputes, the said market could not, the process for settlement of the Sialtec cattle market could not be taken up. It is the opinion of this court that the panchayat authorities are required to get it settled with the help of which district, with the help of the revenue department, with the help of the district administration of Kachar, so that the revenue earned from the market could be used for the purpose of running the panchayat institutions. This court hopes and expects that with effect from 1/7/2026, which is the beginning of the new financial panchayat year, the concerned authorities of the panchayat PNRD department shall take effective steps in consultation with the district administration of Kachar for settling the long dispute, so that the market in question can be placed for settlement. It can be put for, can be bidded out for settlement. And revenue can be earned by the concerned panchayat institutions. With the above observations, both the petition stands.
Hello.
This is the best thought I can. Unless Mr. S. Dutta and his party, he wants to favor some other.
No, man, that allegation is not there, man.
Other markets, they have not issued the NIT in due time.
Okay, let's see.
Obliged.
What has happened in the meantime? Whether the other matter is there today?
The other matter is not here.
Have they filed affidavit of
They
compliance?
have, as per the status report from the website, they have not filed a compliance affidavit. We have filed a compliance affidavit on 8th. And on
Okay, let us have this matter along with the
Along.
record. List this matter along with the records of
5866
oblique
2014.
2014 on Monday.
Obliged, Your Lordship.
I have instruction not to press this matter.
Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner submits that he had instructions not to press the instant application. Accordingly, the instant application stands closed on withdrawal. Ms. So-and-so appears on behalf of the Election Commission of India.
Obliged.
May I please, my lord, this matter relates to non-payment of hire charges bills for the vehicles of the petitioner, my lord.
Higher charges? By whom?
My lord, it was
Who
equation
did not paid you?
No,
Oh,
but
these
it's the-
people.
DGP, my lord, Director General, this is the police department, my lord. To maintain law and order, my lord, vehicles are hired, my lord.
Mr. K. Gogoi, you can appear for all except two. And have you seen the finance council loitering in the corridors?
That Gogoi is there also. I will inform. Just the answer. We will receive.
Okay, so for you, we go for two area, two for people with non-payment of year. Next date is on 5th of October. Ano, 5th of October.
May it please your lordship, my senior counsel is on lax on code number 16. May I pray? Please
Is your
kindly
matter
pray
about-
for I'm being.
Argue, madam. Where's your file?
So,
Where's
Your
your file?
Lordship, my file is with my senior
You
legal
argue.
counsel.
You argue. Let's see what the matter is.
So, Lordship, any arguments by me may affect the
It would
matter.
never affect. I would never dismiss a case when you are arguing. But if your senior comes, you never know. So you argue,
Lordship, the
and I'll always help you out if you are arguing. But if your senior comes, absolutely. How many years of practice?
Lordship, it's not been 2 months yet.
That's second file to be You are also holding my second file. Yes, sir. Absolutely precious.
No, copy of those have to be, that's it. Copy of those have to be, madam.
Then why you are appealing?
But we have a instruction, madam.
What is the case?
The page 61,
Huh?
page 61.
Application for a word of.
Page 67 is the notification.
This is there, na?
Yes. Page 68.
I have dealt with this type of matter once.
Madam.
Yes.
I'm
I was
sorry,
about to issue notice when she was appearing, but you appearing, it may get dismissed.
then my lord, she may continue.
I think better of this.
And my lord,
Yes. Take the file.
Page 68, madam, madam, can you see, madam, page 48? This lands comes up another rural estate, madam, of the national highway. So, page 48, this is the government certificate.
Is within the jurisdiction of so and so. Now the aforesaid woman intends to open outlet on her own. The DP has no objection.
Then page 68, if it is in rural estate of national highway, then clause 2 will come.
Yes.
Where 300 meter.
So you are going by 2.2
Yes,
and that's serial number 2,
cell number 2,
300 meters.
300 meter.
Chalo. So she won the lottery.
Yes,
Ah, very good. I was having a difficulty because I will otherwise dismiss the case. I was just thinking how to issue a notice when she is appealing. Yes, you argue.
my lord, your lordship permits I have.
Yeah, argue. Yes.
My lord, what has happened? My lord, criteria is wrongly applied. My lord, it falls under, my lord, the urban area, municipal area. There is a gazette notification, my lord. This is the gazette notification at page 64.
Let us see the advertisement.
Yes, my lord.
Where's the advertisement?
My lord, the page 29, this is, my lord,
No, where's the advertisement?
the brochures, my lord, are there. This is not part of the brochure.
No, where's the advertisement? advertisement is, this cannot be, there will be a further address. How do you know which petrol pump you are applying?
Yes,
Where?
yes, I'll come to that.
Come
If-
to that.
Yes, yes. Your lordship will come to the impugned order.
Impune order I've looked into.
Yes.
My
the-
question is, where is this? Here it is says regular and rural retail outlet. But you are applying to a particular pump,
Yes, yes.
particular location.
Yes.
Where is the location for that?
Yes, my lord, your lordship will come to page, my lord, 61. This is,
51.
yes, 61, my lord.
Ah.
Annexer 15. This is the impugned order cancelling, my lord, my appointment. Application for award of RO dealership after the address, my lord, at Patharkandi bypass. Your lordship will see from bypass start
No,
point.
no, Mr. Talukdar. When you have this advertisement out there, advertisement categorically puts what is the category, rural or regular. You cannot come up later on. Isn't it, Mr. Bhattakur?
Yes.
If I remember,
Yes.
all these advertisements.
Yes.
No case. I think we
No,
should dismiss it.
no, then that I'll place, that document.
No, you don't get a chance. The junior did not appear, so.
That lordship will kindly give me one chance. Next week, I'll place those documents.
That is the most important document. If you are saying that it is not rural, if it is not rural, but it is a regular petrol pump. In that advertisement where it is there, it categorically mentions that whether it is woman, whether it is so and so, whatever may be, all these things are duly mentioned. And that document is not there.
My lord, if it is rural, my lord, I have no guess, I'll withdraw it. Or lordship will dismiss it.
When
Next,
now?
next week, my lord.
Oh,
At least that chance, my lordship will kindly give me. I have no guess if that is rural.
that is your catch document,
Correct.
isn't it? And you have not appeared earlier. I mean, you are not on caveat.
No, well,
So you want now to take notice. I can't issue notice. You have not filed a no appeal. You take a copy from him.
I've already, my lord, issued copy. Soft copy I've
You
given.
are a standing counsel?
no, we have instruction to appear, madam.
Then obviously can't help. I can't record your name. Heard Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner. The petitioner herein have challenged the rejection of the petitioner's application as a category one, group one, Mr. Group one candidate on the ground that the land which was offered by the petitioner was not as per the specification, in as much as the offered land did not meet the NH norms, as there is an intersection with the road at 150 meters. This court have also taken note of the basis on which the impugned order was passed, that is the circular issued by the MOT dated 26/6/2020, wherein it specifically mentioned at clause 2.2 and more particularly at serial number 2 of the table that the distance of any intersection with any category of road and median gap in respect to location on rural stretches of the national highway has to be 300 meters. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the petitioner submits that the location as well as the land in question, land so offered, do not fall within the ambit of a rural area. And as such, clause 2.2 could not have been made applicable. For that purpose, it is very relevant, like it is the opinion of this court that for deciding the said aspect, the petitioner ought to have enclosed the advertisement containing the locations and more particularly the location which is which the petitioners have applied. The same having not been enclosed, comma. In the opinion of this court, the instant writ petition is incomplete. More particularly to urge the that the location is actually not in a rural area. Mr. S.K. Talukdar therefore submits that he may be granted when 1 week time for the purpose of filing an additional affidavit. Considering the above, list this matter before vacation, after vacation.
Before, my lord.
Before I am there, after I may not.
No, before.
On 22nd of June 2026. In the meantime, the additional affidavit will be filed.
My lord, in the meantime, the task was on date.
Absolutely no, I am not inclined to
My
give
lord.
notice in
My
your.
How less?
uh,
How less, my lord?
No, deductions have already been made.
Huh?
Deductions have already been made, despite the order of this honorable court. All
Where-
that I pray for is Lordship will issue a notice and deduction will be subject to the outcome of the case. Because ERB slips, signatures are there.
I will see.
I was here.
Where is that Mr. M. Sharma?
Actually, process not to be shown as sea oil. That's why Lordship, Mr. Lordship, but is coming.
In any case, Lordship will be issuing
No,
notice.
that day I passed one order. And that is why I'm saying. Now, what has happened? You have been given the ERV slips?
Yes, I have annexed, my lord. No, we have not been given.
So,
Otherwise, my lord.
because 2 days back, I passed a lengthy order to that effect. Whereby there was a notice which was issued, if I still am not wrong, on 22/2025. And thereupon, the petitioner therein sought for 30 days time for filing the writ petition. Subsequent thereto, a writ petition was filed and an order was passed on 17/3/2025 by Justice Jamil. Thereby saying that I give you
The
some.
order we have annexed, my lord.
Mm.
Honorable Justice Jamir's order.
Okay, so they are therefore sought for, they are granted 30 days time and in the meantime granted some more that
Yes.
they may provide certain documents. Thereupon he submitted an application for providing the documents, but documents were not provided. On the other hand, they have
Made the deductions.
made certain deductions. So after this, then I passed a detailed order to that effect, fixing a particular date and saying that you give the ERV slips, the scan copy as well, or oblique the photocopy and or an opportunity is also given for you to verify or compare it with the original in their office at DJ so and so. And thereupon, I also pass an order that no further deduction be made and whatever deduction shall be subject to outcome.
Outcome of the case.
Same order? Same order?
Same order.
Chalo. You sign it, same order.
No, this was the point.
And now here, another 1 day after or 1 day before, like
It
last.
should be IDS matter. The Lordship had fixed.
I have two matters. I have fixed it, if I remember, I fixed it on 7th of August,
Yes.
of which I have granted you time to give the copies on one is on 26th of June, other is on 25th of June.
Yes, ma'am.
Then I have asked them to make the particular comparing within a particular period.
Yes.
And then to submit the documents
Yes.
on the email, submit the so-calls,
My lord.
fixing a date for hearing
Hearing also.
to be heard on or before 1st of August 2026 and the matter to be taken on 7th.
Yes, ma'am.
So you give the dates which is convenient.
Well, here in this case, apart from all these infirmities, there is an excess deduction.
Okay. Excess means there is no requirement of any further deduction.
No, my lord. No. They say that this is what you have taken back, but while deducting from our account, my lord, they have done excess. 19,000 excess. For example, if a
So there is
lordship.
no further deduction in your case.
No, it is already over. My deduction is complete.
Okay, so there is no requirement of passing that no more further deduction.
My lord.
Because you,
Only thing is we have an excess deduction.
it's okay. Any deduction made will be subject.
Yes,
to last line to last. Itna hamar A order to you. You give that and you have to go to Nunmati.
No, my lord, I've re-verified, my lord, after your lordship directed me. I called up the IOCL official at Nunmati, my lord. I have given the address.
That address is okay.
GM
You seen
plan.
the order.
Abhoyapur. That will be the plan.
That is the order which has been passed.
Yes, ma'am. Yes.
I put the right address.
Yes, ma'am. I've given that address, ma'am.
So as per that address.
Relevant plan. Abhoyapur.
Take that order.
LPG plan.
So it would খালি না থাকে no further deduction.
I understand, my lord, in cases where further deductions are there, lordship has put some restraint. But then in that case, my lord, I have one matter love to bring it in that line, opposite. It's one matter where they're making deductions one after another. We have to bring that case.
There, here I passed that order.
Yes,
In
therefore,
fact, now what I have done in these type of matter, I have channelized that.
I followed, my lord.
Do you have a copy of that order? What is the item number? last time?
3020.
We will obtain the copy.
No, you have to
30
look at this because this will help you. I think this is
I
the
don't
order.
know, what's the case like?
3022 and 3033. 3020 and 3033.
To for Monday or Wednesday meeting?
Wednesday, madam. Wednesday.
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 Give you.
You give one date before or after,
Follow.
but the matter is fixed on 7th along with the others.
Yes, ma'am. Sure.
That the petitioner was appointed as the implementation support agency for the AB, PMGOI and Amrit Abhijan matter.
Huh? What do you want?
I was appointed the implementation support agency, my lord, by the contract dated 28/8/20 for a period of 2 years. Then the contract was extended, my lord, on 27/12/22. Then on 30/12/22, my lord, they have imposed a penalty of rupees 3 crore 30 lakhs. No,
Yeah.
my lord, that is, you also find that page 74.
Page?
74.
And why are you approaching this phone now?
My lord, we have submitted a defense and other letters, my lord. in the meantime. But no stoppage has been issued, my lord, as per a contract, my lord, a stoppage is to be issued. Without anything, my lord, they have issued this letter.
So you have paid the money?
My lord, they have deducted it.
So you have
They,
already.
4 crore 20 lakhs, my lord, was lying there and they are not paying anything, my lord. Here, the penalty amount is 3 crores odd, 3 crore 30 lakhs, but 4 crore 20 lakhs are holding, my lord.
But they already deducted.
Well, they kept, my lord, they did not pay the amount, my lord. 4 crore 20 lakhs. Bills are lying, my lord. My lord, your lordship will see the, my lord, software notice is to be issued, my lord, at page 43, my lord, of the contract. Top, my lord. 43. Page 43 of the contract, my lord.
Yes, where?
Top, my lord. I. The SHS shall review the investigation report and if satisfied with the outcomes of the investigation, issues appropriate stoppage notice to the defaulting party. They have to issue a stoppage, my lord. No stoppage has been issued. And we have submitted request on, my lord, explaining everything, my lord, to us, my lord. They have not.
Now, 3 crores have already been deducted.
Well, the 4 crore 20 lakhs, they have not paid. I think it may be deducted, my lord.
So you want that 4 crores.
4 crore 20 lakhs, my lord.
And which department?
It is, my lord, Amrit Abhijan, madam. Probably, my lord, whether REIT will lie or not, entirely based on a contract to private party, the report is unavailable.
Oh, is it?
Yes, madam.
My lord, it is.
Lordship will see page 32.
Abhijan Society.
Health, family plan, insurance,
It is-
CPA.
For the government, my lord.
Why you
Everything.
are making the state of Assam a party?
Yes.
Yes. State of Assam. My lord, it is done by State of Assam, my lord. Amrit Abhijan, my lord. Amrit Abhijan scheme of the Assam. Both, my lord. Two are there.
It is the Union of India scheme, na? Amrit.
Amrit, my lord, the societies are there, my lord, in every state. For,
It
my lord,
is like a-
implementation of the various health scheme. madam.
It is
Yes,
like
yes,
NHM.
yes.
So if NHM against NHM, we could lie, why not? Here?
Lots.
Issue notice, making it returnable on 24th of August 2026. You have accept notice for all?
Yes, I can.
Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the Health and Family Welfare Department, accepts notice on behalf of all the respondents. Extra copies of the petition be served upon him by Monday. The petitioner herein have assailed the recovery notice dated 30/12/2022, whereby a penalty of rupees 3 crores 30 lakhs 44,160 have been imposed upon the petitioner on account of certain fraudulent claims. It is the case of the petitioner that such action could have been only resorted to in terms with 15 Roman I of the agreement,
Influence of.
inasmuch as without issuance of a show cause notice, such unilateral decision could not have been taken. It is the further case of the petitioner that the respondent authorities have not released the amount of rupees 4 lakh crores 20 lakhs 04333, which is the total amount payable to the petitioner. And it is the apprehension of the petitioner that the said amount has not been paid on account of appropriating the penalty amount of rupees 330,44,160, which is not at all permissible. It is under such circumstances the petitioner has approached this court. What is this clause 13.2, page 41?
Yes. 13.2, the imperial health care provider have a right of appeal against rejection of a claim of imperial health by the appeal.
Page 42. Make a claim for damage and.
That is one of the. But here penalty has been imposed. Here penalty has been imposed.
Page 39, Lordship, you will see, my lord. 13, clause 13. It's claim management. Payment of claims.
This court, the respondents herein are directed to bring on record their stand by filing their affidavits. it is observed that though this court have issued notice, but the maintainability of the repetition is kept open on the question of alternative and efficacious remedy, as well as on the ground of delay and laches.
Lordship, the petitioner, the respondent authorities from time to time has hired vehicles from the petitioner.
Huh?
The respondent authorities from time to time has hired vehicles from the petitioner.
Your vehicle,
Yes,
but can you tell me what is the amount you are entitled to? 629.
yes, Lordship.
They have not
62.
paid you.
No, Lordship.
Mr. K. Gogoi? Who has the GAD? GAD is he. Mr. You are GAD? General Administration Department.
Oh, GAD. Yes, sir.
That's GAD I can. So that is GAD. Okay, he appears for GAD. B. Gogoi. And K. Gogoi appears for 2 and 3. A2 Ayapuri to non-payment of dues of 629. Next date is on 5th of October. I'm going to high, man, I very bad. Suppose of no, notice. Yes, what is this?
Your Lordship, I'm assailing the order of suspension, which is in page 25 of the writ petition. It's ordered
There are
suspension, Your Lordship, of my stone crusher unit.
25.
What is-
You're referring to which page?
No, Lordship, mistake of item number. Mistake of item number.
Oh,
Lordship, my case pertains to the non-grant of eligibility certificate under the Industrial and Investment Policy of Assam 2019. I made application in 2023, which is as annexure
this is pertaining to industrial and investment policy of year.
of Assam 2019.
Okay, what is your application for?
Application is for grant of eligibility certificate. I filed my application on 27/12/2023 on page 40, Lordship. Annexure 2.
This is your application, 27/12/2023.
Lordship.
For
Grant of eligibility certificate.
then
Lordship, may turn to page 46, where the DICC forwarded the proposal for eligibility certificate in the year 2025, 29/1 to 2025.
okay, then
Thereafter, Lordship, it is still pending with the respondent authorities, and it has neither been considered nor any order has been passed on the consideration of eligibility certificate.
so you have not got the eligibility certificate.
Not yet, no.
Though applied on 27/12/2023.
Lordship.
In the meantime, industrial policy has no longer.
No, it is continuing, Lordship.
They've extended it.
Yes, they have extended, Lordship. May turn to page 39.
Okay, so now it is there.
It is still there. Unless I have the eligibility certificate, I cannot claim any benefits under the scheme, under the.
Now you have gone for commercial production.
I've already started commercial production.
When?
2023, Lordship.
After that you applied.
Yes, after 10.
And under, you wanted this policy for what purpose?
Policy provides various incentives, Lordship,
What are
tax
the incentives
exemptions,
you are asking for?
power subsidies, Lordship.
Our subsidy.
The various, Lordship, may turn to page 30 onwards of the policy. Fiscal incentives which are available are state goods and services reimbursement. Then other incentives are power subsidies, subsidy on generating
Your
state.
micro, small, medium,
Lordship, medium,
your medium,
Lordship,
as per today.
as per.
There's a difference, no? Because last year it changed.
No, under the scheme, I am medium. This industrial policy.
I think the micro, small and medium will be done as per that act. As per the government act, MSME Act, and there has
Yes.
been an amendment, the
Amendment,
value
but-
has gone much higher now.
Lots of-
The value would be now 50, I think 50 crores or above will be medium. 100 crores. Above 100 is medium. No,
But they have not come out with any amendment.
No, that is the law.
Lots
You
of-
don't require for them. You will fall in different categories now. Maybe you will be now small. If your investment is, how much is your investment? Fixed capital, how much? Investment?
Say, just a minute. 5 crore 78 lakhs.
Then you will be micro.
Micro.
As of now, it's 10 crores is micro.
Yes, sir.
Huh? 10 crores. You are micro. Anyway,
The main issue will be whether the petitioner is a manufacturer of instant tea, whether manufacturing of instant tea, it amounts to manufacturer as per the definition. It will have to be a new product. That part will be main issue. here.
that is the issue.
That will have.
You have not considered, that is his submission.
Yes, yes.
So you may have to come up why you have not
Yes.
considered.
Minus.
See when the matter is. Issue notice making it, how much time to file affidavit?
Immediately after the vacation. Or 4 weeks.
So immediately after the vacation, we make it immediately after 1 month from the vacation. Because for you, immediately would never happen. Issue notice making it returnable on 5th of August 2026. Mr.
I pay for all. of it.
B. Gugoi, the learned
One is the same.
Additional Advocate General,
One.
as well as the Standing Council of the Industries Department, as well as the Finance and Taxation Department, accepts notice on behalf of all the respondents. You can accept for all,
Yes, I pay for all. of it.
because the other is finance and the other is industry. Extra copies of the petition be furnished by Monday. The petitioner company the petitioner claims that being encouraged by the industrial and investment policy of Assam 2019 and the subsequent extensions being granted and encouraged by the industrial and investment policy of Assam 2019. Set up its manufacturing unit and submitted an application on 27/12/2023 claiming for the eligibility certificate in terms with clause 15 of the Industrial and Investment Policy of Assam 2019. Dr. A.K. Todi, the learned counsel appearing on behalf of the petitioner. A. Todi, the learned counsel appearing on behalf of the petitioner, submitted that in the meantime, the said industrial policy have also been extended until further notification. The petitioner is agreed that though such application was filed on 27/12/2023, till date, the petitioner have not been provided the eligibility certificate. And under such circumstances, the petitioner is not in a position to avail the benefits for setting up of his industry. For which, accordingly, the instant petition was filed. The respondents herein are directed to bring on record their stand by filing the affidavit on or before 30th of July 2026. You get it, filed,
My lord. Much.
Yes, madam. You are very anxious to do your matter. Tell me.
So I'm saying, the order of suspension, which is on page 25 of the writ petition. It's order dated 25/2026.
Where's the order?
Sure, what, page 25.
H.
Page 25 of the writ petition.
You have submitted the documents.
Your Lordship, I may be allowed to take you through two more documents. First is the show cause notice, Your Lordship, which is in Annexure 6, page 43.
843.
I'll just read through it.
Okay.
The subject says show cause notice for violation of prescribed rules. With reference to hereby informed that a joint inspection report was conducted on 13/5/2026. It was observed that your stone crusher unit, namely Mrs. Khanikal Stone Crusher, has been utilizing additional land for stocking of minor minerals beyond the approved area of stone crusher unit. The land details follows. The next line says, Your Lordship, in view of the above, you are hereby directed to submit your written explanation within a period of 7 days from the date of issuance of this notice under appropriate rules and provisions. Now, subsequent to this, Your Lordship, Annexure 7, I have filed my response.
Annexure 7.
7, that is 26/5/2026.
Where?
It's page number, Your Lordship, 46. Within a period of 7 days, I filed my response. Precise to point number 6. Sir.
Then
Now, Your Lordship, if we read through the first show cause notice of 19/5, it merely seeks that a reply is required. It does not stipulate or provide any kind of proposed action in case a reply is not provided by you. In compliance thereof, within a period of 7 days, we have submitted our response. Now, Your Lordship, if we go back to the show cause notice, which is of 35 within a period of 4 days that was issued of our reply, it reads, is Your Lordship, in the show cause notice.
page 43.
At the show cause notice is page 25. So I'm reading Annexure 6, 7, and 1.
25 is the order of suspension.
Also, yes, the order of suspension. Right.
Show cause notice is that page.
Right. So in the order of suspension, it said that you are once again asked to submit the documents at the earliest. However, Your Lordship, in the first document that was furnished upon us, the 19/5/2026, it did not provide what are the documents required. However, we ourselves have stated that there are certain.
Where is the forest department? You have served copies?
Yes,
No forest? You wait for some time. Let's get hold of the forest department. It's a matter, my lord, because Supreme Court, my lord, let's say on the private agreement or party, my lord, they cannot do it, but oust the decision of the High Court. They cannot oust. So that is a part of the matter, my lord. That is why, my lord, the High Court will back.
So before issuance of notice by this court,
Yes. My lord, this judgment was not, my lord.
understood. I have to hold that it is for inquiry.
My lord, that your lordship will just see, my lord, it is reported also.
I know. Mr. Sahiwala, the order of both my coordinate bench as well as also the Delhi High Court both are wrong. No quarrel with that. Delhi High Court says that why don't you do it out there in your area? Merely because the office is there. Now, categorically it says, if you see Article 226(2), the jurisdiction is definitely there with Delhi High Court because they have their main office out there. There's no quarrel with that. If we see 226(2) and further the judgments of all other judgments in the case of ONGC, then you have the Adani exports.
Adani, yes, my lord.
They make it very clear where the jurisdiction will be. They say that the same principle of 20 ABC is there.
Yes.
ABC laminates categorically mentions. No, they say that if it is only mentioned that only there the jurisdiction is there, then only otherwise by parties they cannot. I think this must be what has been held by ABC.
ABC referred.
Obviously, this is the law. But the fact remains that why should this court issue notice when they, unless this court holds that that order is per inquiry at the first instance?
Can be, my lord,
Problem
because-
lies there.
That can be, my lord, because
Mr. Sahiwala, what happened after that day you moved the matter on Wednesday? I've been thinking, how will this court do? On the face of it, there is an order. I have to hold that the order is per inquiry for issuance of notice, because otherwise I don't have the jurisdiction. How do I do it?
my lord, that will be part of the matter.
How do I do it now?
My lord,
Means I have to hold it per inquiry at the instance without issuing notice, because my jurisdiction, my coordinate bench has taken it away, because there is no separate cause of action. Wouldn't it be res judicata? You see, the problem is that it would be a res judicata. If it is a res judicata, I cannot go ahead and res judicata is duly applicable in this law.
Yes, but one thing, my lord, that
Why don't you file a review? This is the only way out. I'll keep this matter pending, file a review, do something to the effect. But otherwise, there is a big problem for a case.
review will be time back, my lord, now.
I also know, you also know what to do. If you file a review, because this has happened, now we have standed anywhere. You should have pointed out the judgment of this court when we were appearing in Delhi High Court. Why didn't you point it out? That you look here, I can't go to the Gauhati High Court because of this judgment.
My lord, I had a talk with the counsel at Delhi, my lord. He said that he has considered written nothing, my lord. Charge has written nothing. But he has considered the judgment as well as this Supreme Court judgment, because in paragraph 25-26 is absolutely clear, my lord. In this
Show me your petition filed in the Delhi Act. Produce the petition, because obviously you'll be mentioning the jurisdiction there on the basis of this judgment.
Yes.
Obviously be mentioning, and if it is considered, otherwise give me something to show somewhere. I know you have a right, but the problem is because of that order. And I cannot do anything unless you file an appeal. File an appeal against that order of Mrs. Surana. That's the only way out I can take it up. Because otherwise I'm bound by res judicata. How do I now escape this problem? The only way is either file a review or file an appeal for this court to take it up. Issuance of notice is no problem out there, but how do I issue notice when expressly in respect to the same subject matter it has been held?
Difficult.
This matter is still before the same bench matter than Justice Collins.
Huh? I don't have that power, nah. Number 10.
I'm sorry. Otherwise, also, my lord, that my lord, when they have admitted amount, should not have, my lord, they should have paid, my lord. When after verification, they have done it, my lord. Why then?
All understood. Problem lies when I saw the Delhi High Court.
But so bit, my lord, that is parliamentarian, that is correct, my lord, in view of this. That was a special, only this question was apart, my lord, in this case.
What is the distinguishing cause of action from there and this? Same.
Well, further action around here because the work was done here.
Understood, but then also problem lies with the learned civil judge. Why didn't you file an appeal? Think about it. Let me think also. Again, next week.
Well,
Day is what? 15. Let us again think on 19th.
Well,
What can be done? I'm trying to help you out, but I'm not getting any way where to go.
well,
Because I'm issuance of notice, I can very well issue a notice. They will come up with it because my jurisdiction has been just, my wings have been
well,
cut.
absolutely. I shall look out for both.
There's the math on. 19th, huh?
But if today we have received our instructions, then we will file out.
What you have filed affidavit?
But if today we have received the instructions. As per enquiry report submitted by the Lordship Executive Magistrate Office of the 4th District Commissioner Landing and technical team headed by the Executive Engineer Hosea Jilla Parishad.
Show me. First of all, you were supposed to file affidavit. You have not filed affidavit.
That's it.
We impose a cost upon you.
But
10,000 rupees upon you. That will reduce the amount from 28 lakhs 19,600 to 28 lakhs 9,000.
that's it today.
10,000 on Miss Endora for not filing. Then another 2-3 councils of all standing council, another 10,000. What is this? As per the inquiry report submitted by the executive engineer and the technical head, showing for running bill of rupees 20 was prepared and processed for payment. However, due to the ongoing high court case number filed by the contractor. Okay. So you pay him this amount. There's no problem. This is the matter because of which you are doing it. You have withheld. I've never heard that because of a petition being filed for the purpose of getting the money gets withheld. Isn't it the most funny thing?
District Commissioner. Then the District Commissioner.
No, that is the remark.
That's it.
As per the inquiry report submitted by the executive magistrate officer and so and so, a running bill amount of rupees 18 lakh 71,000 here was prepared and processed for payment to the contractor for both the scheme. However, due to the ongoing repetition, payment has been withheld. Can there be any more funnier incident which can happen with your departments? Do one thing, the money which has been processed, make the payment as regards the remaining amount, if he has any claim. Observations, what was not done and what. So as regards 18 lakh 71,000, you pay within 3 months as it is processed for payment is mentioned. And remaining amount, you get the liberty to file a check. Okay?
Yes, ma'am.
Better off? Don't ask more than that.
But they have already admitted the fact, admitted the amount, 28 lakhs.
No, they have not. They are only admitting 18,71,000. So therefore, take that money and get the petrol for fighting a civil suit for the remaining 9 lakhs along with interest. Better off. Because of the pendency of this petition, they have not. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Miss N. Bora appears on behalf of the respondent numbers 1, 2, 3,
1, 2, 3, 7, 8,
7, 8,
and 13.
and 13. Miss R. A. Talukdar appears, Mr. for respondent number 4. K. Gogoi for respondent number 6. Huh? 6 to 6 and 9. Okay, chalo. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not making payment of an amount of rupees 28,19,657 to which the petitioner claims to be entitled to. It is a specific case of the petitioner that the petitioner was issued a letter a contract for construction of dilapidated GP office building under SOPD for the year 2017-18 at the quoted rate of rupees 72 lakhs by the communication dated 13/11/2019. Subsequent thereto, the formal work order was issued on 25/11/2019. It is a specific case of the petitioner that the petitioner, you could not complete the work.
Completed, handed over. Completed, handed over.
Conducted verification.
Kindly stay,
Where is your statement that you have completed?
kindly see the page number 71, the annex 8.
Huh?
7 and 8. Page number
Page?
71. Already were handed over to the Hoop Lumbing Gaon Panchayat, which is a certificate issued to us. Well, 71 and 72. Two dilapidated buildings have been handed over.
It is the specific case of the petitioner that the entire work was completed and handed over to the Poop Lumbing
Gaon Panchayat.
Gaon Panchayat. And to that regard, a certificate was issued on 12/10/2022. Similarly, the Bhalukmari Gaon Panchayat has also issued a certificate to that effect. It is the further case of the petitioner that the petitioner received certain running account amounts to the tune of rupees 43,79,593. And accordingly, the petitioner was entitled to rupees 28,19,657. However, as the petitioner did not receive the amount in spite of various representation, the petitioner approached this court by filing the present writ petition. This court duly takes note of that by an order dated 28/10/2024, notice was issued. Until date, no affidavit was filed in spite of specific directions being issued. Today, when the matter is being taken up, Ms. Enbora, appearing on behalf of the PNRD department, as well as the other respondents, as well as some of the other respondents, submitted a statement showing the status of the civil works under SOPD, and more particularly in respect to the work which was carried out by the petitioner, that is, construction of the dilapidated GP building, bracket 2 numbers at Bhalukmari and Poob Lamding GP. Along with the said document, the respondents also enclosed the various inspection reports. The said statement along with the inspection reports are kept on record and marked with the letter X. From the said inspection report, it is seen from the said statement, it is seen that 86.5% of the work have been completed, and the financial progress was 58%, and the current status to be ongoing. It was also mentioned that a running account bill amounting to rupees 1871,521 was prepared and processed for payment to be made to the petitioner for both the schemes. However, due to the present litigation, present petition, the said payment have not been made to the petitioner. In addition to that, it is also mentioned that in respect to Bhalukmari GP office building, worth 5,09,107, and in respect to Poob Lamding GP office building, worth rupees 4,91,147 have not been done. So, the learned counsel appearing on behalf of the petitioner, on the other hand, submits that the entire work have been done and the buildings have already been handed over in the year 2022-23, which is apparent from the certificates being given by both the Gaon Panchayat. In addition to that, the work completion certificate as well as the final running bill which have been prepared also shows that the entire work has been completed. This court has given an anxious consideration to the aforementioned aspects. And it is the opinion of this court that as the respondents duly admit that the petitioner is entitled to the amount of rupees 18,71,521, 521, and it is on account of the present writ petition, the said payment have not been made to the petitioner. the payment have not been made to the petitioner, certain directions are required to be passed in that regard. It is also the opinion of this court that the dispute as to whether the petitioner have completed the works at Bhalukmari GP building as well as Pum Lambing GP building are questions of facts which needs to be adjudicated before a court of competent jurisdiction. Accordingly, the writ petition stands disposed of with the following observations and directions. First, the respondents in the PNRD, and more particularly, the respondent number 3, 8, 3, 6, 8, and 13 are jointly and severely directed to release the amount of rupees 18,71,521 to the petitioner within a period of 3 months from the date of service of the certified copy of the present order to the respective respondents, to the said respondent number so and so, number 2. It is further observed that if the amount is not paid within the period of 3 months as directed herein above, the said amount shall entail interest at the rate of 9% per annum from the completion of the period of 3 months as directed above. Insofar as the amount of rupees 5,09,107 and rupees next. So far as the amount of rupees 5,09,107 and rupees 4,91,147. This court grants the petitioner the liberty to approach the competent court of civil jurisdiction and the period during which the instant writ petition has been pending, that is from 4/10/2024 till date, be excluded while computing the period of limitation. First, it is next. It is further observed and directed that this court, having not adjudicated on the claims of rupees 5,09,107 and rupees 4,91,147, shall not in any manner be deemed that this court have decided that anything against the petitioner in respect to the said amounts. 7 also. 7 also. 7 over. One is you, others are she.
On compliance of the order dated 4/12/2024. Service has been completed regarding respondent 1.
Actually, these are non-payment of contractual bills. The services, the supply was given by the district commissioner.
Yes. No, we have made it supply to the customer.
Yes.
Service not complete.
My lord, we have taken steps, but the office note is very old, basically.
They've not looked into it properly. Office note is as new as 10/6/2026.
Oh, I might miss them.
Will have missed. You take service by way of the stick.
I'll do that.
This court duly takes note of the office note dated 10/6/2026, which reflects that the notices upon the respondent number 2 and 3 have returned unserved on the ground of ineligible postal notes. The counsel appearing on behalf of the petitioner submits that he would like to take steps by way of the state upon the respondent number 2 and 3. Taking into account the repetition, the instant application is directed to be listed on 24th of July 2026. In the meantime, the petitioner is directed to effect service upon the respondent number 2 and 3 by way of the scheme routed to the registry of this court and file an affidavit of service on or before the next day. The petitioner should ensure that the service is meted out upon the respondent number 2 and 3 by way of the state on or before 26th of June 2026.
That's all right.
Non-payment of contractual liability money. They have filed an affidavit admitting the amount.
You are,
Yes, Allah.
you are also famous with Kiva.
Yes, madam.
2 lakhs.
Yes, madam. 2 lakhs. Remaining amount 2 lakhs.
This was a provision. But Kiva judgment, you have Kiva judgment?
Yes, yes. I'll provide it.
Affidavit of authorization.
Please, because of my default, madam. Because of my default, madam. I have.
What happened?
Was cited paragraph number 12, madam. Action has been taken that affidavit and those cases disposed.
It has been disposed of.
Disposed of, but affidavit was supposed to be done. That affidavit will be filed, madam. Even after it is disposed of, madam. The action has been taken, madam. That's communicated to me, madam. That paragraph 12.
You affidavit to comply with file.
Just communicated, madam, but
They will comply with.
complied with, madam. What is the report next week?
No, why haven't you filed the
No,
affidavit?
that's to do to my oversight, madam. This particular paragraph.
File the affidavit.
Lordship.
because It's the order.
Lordship.
Mr. Esbora appearing on behalf of the Gauhati Municipal Corporation submits that the directions so passed by this court in the judgment and order dated 16/2/2026 in the instant with petition have been duly complied with. He however submits that the affidavit will be filed within 7 days. List the with petition also accordingly time is granted the time is granted to file the affidavit on or before 23rd of June 2026. Failure to do so, the matter be again listed before this court. Next time, no more excuses.
And the letter to the chief executive officer for report on territorial possession. Submit the report of territorial possession.
My question is whether you have taken the decision The decision is not upon the Jila Parishad or in. The decision is to be taken by the government.
That's going to take decision after the, because let's say we have not received till date the report from the chief executive officer.
That can't be.
So let's say,
Judgment is made very clear.
let's
So you're not carried out. So we should initiate contempt against this person concerned. Secretary to the government of Assam, Panchayat and Legal. No, you can't put that all. See the direction in my order,
let's see.
the order which was passed. As the dispute projected in the petition by the petitioner Gaon Panchayat is one regarding the area of tree markets. And the bone of contention among the petitioner Gaon Panchayat so and so, so and so, and so and so, it clearly falls within the nature of dispute and resides under 135 of the Act. Therefore, instead of making an endeavor to adjudicate the dispute wherein factual dispute would also fall for consideration, this court is of the considered that the repetition is not to be entertained at this stage. Instead, as the state government has the authority to decide such a dispute, the dispute be referred to the state government for resolution. It is ordered accordingly. It is observed that the state government, while adjudicating the dispute, shall provide an opportunity of hearing to all the involved authorities and can take assistance of the jurisdictional revenue authorities and relevant land records if need be assigned. The decision shall be made as expeditiously as possible, preferably within a period of 45 days from today. Direction is to the state government. Then you are putting the blame on them. This type of explanation is not. I have it after vacation to carry out this thing. This thing. In pursuance to the order dated 22/5/2026, an instruction has been placed by Ms. N. Bora appearing on behalf of the Secretary to the Government of Assam Panchayat and Rural Development Department, wherein it is mentioned that the Chief Executive Officer Gwalpara Jila Parishad have not been cooperating with the Panchayat and Rural Development Department, for which the directions passed by this court, by the learned coordinate bench of this court dated 18/2/2026 in WPC number 885/2026 could not be complied with. This court specifically inquired with Ms. N. Bora, the Standing Counsel of the PNRD Department, as to whether the PNRD Department has control over the Jila Parishad or not. No control. Say no control. I'm asking you whether they have the control or not.
Yes, control.
The learned counsel submits that, Standing Counsel submits that the PNRD Department of the Government of Assam has control over the concerned Jila Parishad. If that be so, this court fails to understand as to why, in spite of communications being sent to the Chief Executive Officer Gwalpara Jila Parishad, the Commissioner and the Secretary to the Government of Assam Panchayat and Rural Development Department have not been able to effect compliance to the directions passed by this court in the order dated 18/2/2026 in WPC number 885/2026. It is the opinion of this court that the instructions so placed do not appear to be in good taste, appear to be in keeping in mind, appear to be with an intent to carry out the directions passed by this court on 18/2/2026 in WPC number 885/2026. And as such, this court was of the opinion that contempt proceedings should have been initiated against the concerned respondents contender. However, Ms. N. Bora, appearing on behalf of the Standing Council of the Standing Council appearing on behalf of the PNR, the department submits that some more time may be granted so that the order dated 18/2/2026 passed in WPC number 885/2026 can be complied with. List this matter on 27/2026 for an update. Madam, next time, if the matter comes. Contempt. What is this I business?
There are two eyes, madam. One is for both of implements.
Implement.
Yes, madam.
One person pleading
One was filed by me.
and the other.
Other, my lord, he has newly come and he has wants to be pleading. I only want the complaint, my lord, in the complaint petition, in the one with the complaint. And some serious allegation is raised against me, my lord, in the writ petition. And they did not make me as a party to the petition, my lord.
Who? Who is the writ petition?
My lord, they are the writ petition, my lord.
So you file an application to impeach somebody.
No, no, my lord. Not him. I filed an application for implementing the government agency, that is a government departments, my lord, that is the police department of North Gauhati. As I
He
made
wants-
complaints and those were not.
And you want to be a partner.
Yeah. And in those complaints, it's
IA number 1468/2026. It is an application to file to implead the opposite party numbers. 3, 4, and 5. Whom do you want to implead?
my lord is taking I-468,
Absolutely.
my lord, page 3.
Whom
Page
do you want to implead?
my lord, Superintendent of Police, Officer in Charge, North Guwahati Municipal Board, and Vice Chairman, North Guwahati Municipal Board. They would be appearing as 5, 6, 7, and 8 in the writ petition.
So officer in charge also.
Yes, my lord. We have not taken the complaints.
The instant application has been filed to implead. Now, Mr. Counsel, if you implead,
Yes, my lord.
I'm asking you, where is the respective allegation against these persons?
My lord, what has happened in this matter is that when we went and gave the complaints against that these people have been harassing us for running the store.
If
There
this
was no-
person is also harassing,
My lord, no, my lord. Their inaction was the problem for which we have brought.
so therefore, where is your allegation?
My lord, but the allegation for number 3 and 4 is there because in this matter,
Mr. Counsel, my question is, how is 1, 2, 3, and 4, opposite party 1, 2, and 3, and 4? If I make them party without there being allegation, how do you
my lord,
how do you succeed in the petition? My question is that.
I agree to that. My lord, because under 226, I could not be making the police in action if party. My lord, on the last occasion, it has been directed to us to take steps upon them and make them.
It makes no sense.
But my lord, for number 3 and 4, my lord, that would be required. The municipal board.
Huh?
The municipal board would be required. Number
But you have to put some allegation against them,
yes, my lord.
some statement. Where is the statement out here in the writ petition? My question is.
No, my lord, in the writ petition, only the
He
complaint.
wants to implead, it is okay. That is a different thing. But if you are the petitioner.
Yes, my lord.
If he comes in, there is no problem with that. But for you to bring somebody as a respondent, you have to have something against him. Otherwise, why will he be a necessary party if you don't have allegations in the petition?
My lord, with regard to amendments that
The only way out is you withdraw with the liberty to refile and bring all these people a party, matter over.
My
That
lord-
is the only way out.
my lord, then for this moment, my lord, the IA will be kept against, my lord. The other implement, that application, that can be allowed.
I will dismiss your eye.
Yes, my lord.
To dismiss
because
your
why I
order.
say that, my lord?
Because there being no allegation in the petition against this person, we cannot include them because they are not necessary. What do you say?
Yes, my lord, because,
Yeah, because they have to have.
yeah, my lord, Lordship is absolutely correct.
And because of that, you'll be more in more bigger trouble. Do you understand that with this dismissal?
No, my lord, slightly there has been changes. What has happened is, when I wanted to make the municipal board party at that period of time, it was a necessity to get their NOC objection. But now the rules have changed. Now there is no such requirement.
So you withdraw this app.
I'll withdraw this application.
Aye. Okay. The learned counsel appearing on behalf of the petitioner submits that the petitioner do not want to impede the opposite parties of the present application as parties to the accompanying writ petition. He therefore submits that the petitioner would like to withdraw the instant application. Accordingly, the instant application stands closed on withdrawal. Now comes the law. This is an application filed by the applicant who seeks impleadment as the respondent number 3. Respondent number 5. As the respondent number 5 to the accompanying writ petition on the ground that the applicants were the objectors to the license which have been issued to the petitioner, and the petitioner have not impleaded them in the accompanying writ petition.
Actually, yes, my lord, they have raised allegation in the writ petition.
So, taking into account the above, it is the opinion of this court that the applicants in the instant application are necessary parties to the accompanying writ petition. More particularly, as specific allegations have been leveled against the applicants. In that view of the matter, this court allows the instant application by impleading the applicants to the accompanying writ petition as respondent number 5 and 6. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days from today. And the registry shall, on the basis thereof, make necessary corrections in the cause title, as well as update the same in the CIS. I stands disposed. Now you cannot do. Issue notice upon the newly impleaded respondent number 5 and 6, returnable on 17th of August 2026. Mr. Siladitya, the learned counsel, accepts notice on behalf of the newly impleaded respondent number 5 and 6. Extra copies of the writ petition be furnished to him by Monday. The affidavit on behalf of the respondent number 5 and 6, as well as the other respondents, be filed on or before 12th of August 2026.
Lordship, may kindly peruse the order dated 29/4,
Right.
whereby your lordship has fixed the matter for file and disposal on 60th at 2 p.m. On 60th.
Then
And today is the day for filing our reply. So we are going to file reply. In the meantime, they have filed one IA.
who has filed a?
That's one number.
The
4.
private respondent.
Why?
Lordship, under section 17B of Industrial Disputes Act.
Oh.
Let the whole matter be heard in the next on 16th.
They don't be. They just stay.
No, no.
You want to file objection?
Yes.
I gonna be. Mr. A. Bhattacharjee appearing on behalf of the opposite party, who is the writ petitioner in the opposite party number 1, who is the writ petitioner in the accompanying writ petition, submits that the opposite party number 1 would like to file an objection to the application filed to the present application. List this matter again. তার আগতে এটা কাম কৰিব না issue notice issue notice making it returnable on 22nd of July 2026. Mr. P. Gogoi accepts notice on behalf of the respondent number 1 and 2, opposite party number 1 and 2, opposite party number 2 and 3. Mr. A. Bhattacharjee accepts notice on behalf of the opposite party number 1. Mr. K. Gogoi, the learned counsel submits that the opposite party number 2 and 3 would not like to file any objection. On the other hand, Mr. A. Bhattacharjee submits that he would like to file objection to the instant application. The objection be filed on or before will be civilization. 22 on or before 17th of July 2026. Right.
Treatment of party member. He is 9 is the other past that is honorable court.
Whom do you want to include?
He is 5 Malak, Union of India represented by Government of India, Ministry of Jals, Sram Shakti.
Is an application filed by the applicant, who is the petitioner in the accompanying writ petition, to implead the Union of India as well as the Brahmaputra Board as part respondent number 4 and 5 to the accompanying writ petition, taking into account that the claim made by the writ petitioner arises out of a project which is centrally sponsored. It is the requirement that the Union of India as well as the Brahmaputra Board should be made, and it is the ought to be made parties to the accompanying writ petition. Accordingly, take it up page 5 Union of India represented by so and so and the Brahmaputra Board page 5 are included as the respondent numbers 4 and 5 to the accompanying writ petition. The learned counsel appearing on behalf of the petitioner, the icon file icon pulbo and the icon memo parties shall file a memo of parties before the registry of this court within 7 days, and the registry shall make necessary changes in the course title and update the same in the CIS of the accompanying writ petition and update the IS as disposed. Issue notice upon the newly completed respondent number 4 and 5, returnable on 10th of August 2026. A. Gayan, is the expert on this. Ms. A. Gayan, the learned CGC, accepts notice on behalf of the respondent number 4 and 5. Extra copies of the writ petition be served upon her by Monday. The respondent number 4 and 5 shall file their response on or before 5th of August 2026.
Now, please, Your Lordship. The landlord tenant dispute was there and electricity was disconnected pursuant to your Lordship's order. We have obtained the electricity connection without the NOC. And in terms of the order, we have also served, and the affidavit of service has also been filed. And my lord, may kindly have page 48 of the affidavit of.
You got the
service.
electricity?
Yes, my lord.
Yes, now.
Nothing
Service.
survives, my lord. At page 48, my lord, it has been served.
An affidavit has been filed and when in the affidavit, paragraph 2, it is stated the notice was duly served upon the respondent filed on behalf of the respondent filed right to be. Which 6, 7 and 8?
My lord, 6, 7 and 8 are the daughters of 5.
Okay. She has accepted it.
Yes, ma'am.
You can accept it.
My lord.
This court have duly taken note of the affidavit of service which has been filed by the petitioner and more particularly to paragraph number 2. And taking into account that the respondent number 5, who is the mother of the respondent number 6, 7, and 8, had accepted this notice on her behalf as well as on behalf of the respondent number 6, 7, and 8. This court deems that the service upon the respondent numbers 5, 6, 7, and 8 is complete. Are complete. This is the matter for admission on after vacation on 24th of July 2026. It's an interesting case, Mr. Gogoi. Let me show you what happens when you give interim order extension. See, first matter comes up on 9/4/2000, no, on 28/2/2025. Time is taken.
Adjournment was.
12/3/2025, prayer for interim order shall be considered on the returnable date.
2/4 that is possible.
Then 2/4, no, nothing mentioned. 9/4, the impugn order details and other consequences shall be subject to the outcome of the dispute. This can't be considered as an interim order. Then 11/5, it says the interim order passed earlier shall continue till the next day. Okay, service being complete, list the matter for admission on 27th of July 2026. This court finds it very pertinent to observe that there is no interim orders passed in the instant proceedings.
Yesterday, respondent has filed one affidavit in opposition, so we have to file our plan.
Why the matter has come up like this? Service upon the AR is complete. Okay, service is complete, yeah?
Service is complete.
You want to file a reply?
Yes.
Who is to file an additional affidavit?
Respondent 6, senior superintendent of police.
You have filed the additional. Mr. K. Gogoi, the learned counsel, appearing, learned additional senior government advocate submits that the affidavit, additional affidavit has been filed in pursuant to the direction passed by this court on 15/5/2026. The counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply to the affidavit in opposition filed by respondent number 3. Urgency, no urgency? No urgency. What is the matter about?
Your Honor, we are the lessee. Respondent line at the imports PROCEED.
Okay, list the matter on 3rd of August 2026. In the meantime, the reply be filed. But so. Yes, forest. Where is the forest? What is this, what you have done? Have you seen the file?
We have not been able to get a copy of the petition.
It has been duly served. Huh?
Yes, my senior took the copy with him, my lord. Digo, he was here, my lord. Now
He is not appearing. When a matter is called up, what to do? Take the copy and we'll take it up at 2. Have a look at it.
Yes.
Because what has happened is this. A submission is very simple. You issue a notice saying that, look here, these are the particular, you have been allotted of some 6 bighas of land or something for carrying out of this stone crusher unit. You are putting various, you are loading or you are keeping the raw material, the minor minerals in some other area outside the, in particular dark numbers. And as such, so cause he replied. Thereupon, the entire operation is suspended on the ground that the petitioner have not supplied the materials on which was never asked. I think that's so, isn't it? Okay.
During this case, my lord, allotment of second class is to Kachat district.
What?
Second class fishery, that was allotted under section, under rule 14 of the registration.
It has been given to whom?
Initially given to us, my lord, the petitioners, my lord, and subsequently, my lord, again, they have allotted another 42% along with us, my lord. From the same families.
From the same?
Same families, my lord, those who are allotted earlier, my lord, and then this is a small fishery, my lord, and our issue is that, my lord, in fact, my lord, from these families, they are already represented. And as per factual report, my lord, submitted by the.
What are you challenging?
I am challenging the, my lord, order, my lord.
Where is
Page
the order?
62, my lord, type copy, 64, my lord, type copy, my lord.
What is the period for settlement?
My lord,
What is the period for settlement?
there is no period, my lord. In fact, they have been paying the land revenue, my lord. But the government, my lord, as per rule, my lord.
Well, my question is, you are challenging which order?
I am challenging that order 64 page, order dated 59/2020, page 64, my lord. That's it.
Settlement officer. Then
my lord, we have challenged this order, my lord. In fact, we are now paying the revenue as well as we are
running it.
running it.
Then what do you mean?
My lord, they have, there is issues, my lord, since, my lord, these people have been obstructing, my lord, and from the same families, my lord.
What
Your
did they
lordship,
say in the reply? Your name is Abhiram Das. First party Abhiram Das submitted that the aforesaid fishery is a small fishery.
My lord.
Names have already been included as representatives from the family of the second party. and they are related with one another, but the matter could not be disposed in negotiation by both the parties for which dispute arose. The circle officer so and so furnished the report that no objection had been filed from earlier representatives for inclusion of the petitioner. In the aforesaid fact, which court officer passed an order including the names of the second party and directed the concerned here for realization of government revenue as per the current assessment by observing the formality. Yeah. Very difficult to understand what has happened here.
My lord, because my lord, in fact, my lord, as per their.
You are running. We
My lord,
happy.
that is-
Why you are challenging that?
But these people have entered into this arena, my lord. That's why we are.
Why
facing-
should we decide all these things in a repetition?
In their affidavit also, my lord, the affidavit submitted by the settlement officer, your lordship may found it.
I've seen
There are
that.
6.
Their name have been inserted, understood. But what is your case? I have not been able to understand.
My case is that, my lord, they are the representative, we are the representative. And from us, my lord, amongst us,
You are the
another people have been,
representative of what?
my lord,
You are the representative of what?
initially we have been allotted, my lord, for 220 people, my lord.
No, no,
Subsequently,
no,
they have,
no, no. It's a settlement of a fishery. Isn't it?
my lord,
If it is a settlement of a fishery, it has been given to individuals or some society or
individuals, my lord, individuals.
who was,
The initially petitioners were allotted. my lord.
how can so many petitioners be allotted one fishery?
That is the order, your lordship.
Let's see.
Page 39, my lord.
Page?
Page 39, Annex 4. 39. That is order dated 2/5,
It
2016.
is seen from the reports and submitted by the assistant settlement officer that the following petitioner applied for inclusion of their name in the water body of the second class fishery under the schedule below.
These are the petitioners, my lord.
And so they wanted, this is not a settlement,
No, my lord, this is allotment, my lord.
allotment for, this is allotment made under what
Allotment for,
provision?
allotment for fishing, my lord. Only our right is only to that extent for fishing.
And now what is happening?
Now, my
There
lord,
are other people who are fishing.
yes, my lord, another 40 people have been
So what
included
is
in.
your right?
My lord,
What is your right?
my lord, we have been paying the revenue, my lord, for this,
So
my lord.
they will also pay.
No, my lord, they are not paying, my lord.
They will pay or not, they don't pay, that is their lookout. Why should
Because-
we interfere with all these things?
Your,
Whoever gets it.
my lord, your
This
lordship,
court is not
kindly-
going to do. What is
factual
it
report-
illegal?
factual
Where's
report,
Mr. Gogoi? Huh?
factual report page.
Go before the civil court. This court is not going to look into all this. Whether what is your right on the basis of this order? And what is the basis of this order? Can they for eternity only give to these 20 persons?
Page, rule 14, my lord. On the
Of-
basis of rule 14 of fishery rules, my lord.
Very useful, sir. Fishery.
My lord, I have,
I also have. Where is the revenue department?
in fact, that is also
Rule 14.
rule 14, my lord. Settlement of fisheries as land.
Settlement of fisheries as land. Fisheries cannot be settled as land. In Kachar, however, this is Kachar.
Yes, my lord.
Small and second class fisheries which adjoin settled land shall be entered in a separate register in the deputy commissioner's office and not included in the original journal list. The lease of such fishery is in special form sanctioned at the time of resettlement. Fisheries which have silted or shall be settled as per year. And for the terms of the lease, the rights of the lessee extend to fishing only, and they cannot acquire the status of the lease. So the only requirement is shall be entered in only which adjoins settled land shall be entered. So are you saying that the respondent number 4 to 6 to 47, the lands are not adjoining?
In fact, my lord, they are the relatives of one another, my lord.
So
We have submitted our objection before the settlement officer, my lord, but without considering our submission, my lord, objection, my lord, written objection, they have settlement officer passed the order, my lord, by including the name, my lord. It is our grievance only. And our objection, my lord, we have. Annexure 8, my lord, our objection is case 58, my lord.
it will be given by whom? Deputy Commissioner. But it will be done by the.
By
Deputy
the
Commissioner.
settlement officer, my lord.
Why the settlement officer coming into picture? The leave for such fishery is in special form sanctioned at the time of resettlement. These are questions of facts. You go there somewhere.
Included losses. The persons, the 41 persons who has included losses, they are the representative of the earlier settlement of the force.
Then.
That is not correct, my lord. In fact,
Ah,
in our reply,
Why should he decide? This court
Even
is
the
not
report,
going to-
even the report is there also.
that report we have
I've
denied,
seen
my
the
lord. Since, my lord,
affidavit.
this is the
No,
first time, my lord.
affidavit categorically says that. Yeah. Here says, moreover, the circle officer
Yes.
furnished a report that no objections have been formed from the earlier representative. for
Lordship,
inclusion of the
lordship, the report. was-
In the aforesaid fact, the office has passed an order including the names of the second party and directed the concerned so and so as per here. So what is wrong?
More so, my lord, in the para 6, more so, we then the circle officer, Eastern Settlement category of furnished a report that no objection has been found from the earlier
So
representative.
if this
inclusion
is
of the
an
petitioner.
order passed under 14 of the settlement rules or the fishery rules, and appeal lies to the Board of Revenue. I suppose. Board of Revenue. The Board of Revenue is there, go there, not here.
Then also the list was the persons that even also another report is also there, the persons and persons who are included by them is not known to the other parties also. This.
Yeah,
That-
I know that.
that
This is
report I
an
have-
absolute criminal.
That report I have annexed. to it.
These type of things cannot be, we need to finish up this. The appeal lines.
But one order of your.
On the settlement officer's order, Assam fishery. Now, you have a copy of the fishery rules? Well, now, if you see section rule 14, settlement
14 losses.
of fisheries as land.
Losses.
Fisheries cannot be settled as land in Kachar, however, small and second class way which adjoin settled land shall be entered in a separate register in the Deputy Commissioner's office and not included in the original Jamabandi. The lease for such fishery is in a special form sanctioned at the time of resettlement. Fisheries which have been silted or shall be settled as wasteland under the so and so. Then the rights of the so and so shall be settled to the best. Then there is a person who can be appointed specifically to collect. Fisheries of the river Barak and so are the areas of the single moja, provided that the settlement shall be subject the settlement proposal of second class to the Commissioner of Appeal for approval. Okay, fishery in upper reaches of Barak Valley. Now kindly come to 11.
What's it?
11.
11 was.
all appeals against the order of settling authority
Board of Revenue.
passed under these areas shall lie to the Assam Board of Revenue. Now my question is whether Rule 14 is encompassed. It appears so.
This is second from, starting from second line also.
Because they earlier, if you see, earlier they had the word. You see, earlier says appeal against order of the conforming authority. Now they have put settling authority.
Settling authority.
Now, whether this settlement which is there, now this is a settlement to be made, normally the deputy commissioner has the power to grant the settlement on the basis of if it is a land. Now, if we see the some land and revenue regulation, more particularly 16, if I'm not wrong, 16. The right, the deputy commissioner with the previous sanction of the state government may by proclamation published in the prescribed declare any collection of water so and so, so and so, so and so shall be a fishery and after commencement of this regulation except as provided in the rules made under 155. So these rules may have been made under 155. Provided that nothing in this section shall affect any express grant of right of speech made by or on behalf of the government or any man acquired by the proprietor before the commencement or the acquisition of so and so. So this is the right which comes from here and here. Now, if you see the Board of Revenue regulation, here the problem is passing an order is also tomorrow I pass an order, then here. Now, classes of cases to be heard by the benches. Now you see, Fishery Rule 11 appeal lies to the Board of Revenue. It should be. Because this court cannot decide this. And more particularly, it is an order taken by the settlement officer. If it is an order passed under by the settlement officer, normally under 147, an appeal lies. From a, or even it lie to the deputy commissioner. Who has passed the order? Assistant?
Settlement officer, madam.
Settlement or assistant?
No, settlement.
So therefore, if it is so, they can go to the board under 147.
Go to the board.
So you go to the board. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. K. Gugoi appears on behalf of the respondent numbers. Also 2, 3, 4, and 5. 2 to 5. 2 to 5. Mr. So-and-so appears for respondent number 1. Yes, Mr. Hendrik, what do you say? You are the main problem. Understood, but this is not an order passed under the land and revenue. It's an order passed under, it is an order passed under 11. 11, 14. Normally it is to be done. In fact, what the deputy commissioner does, the deputy commissioner enters the nearby lands and thereupon nearby lands and then gives them some, that is only in small fishery. They allow them to fishing rights, subject to payment of some revenue. So the once the revenue comes into the picture, So therefore, this is a settlement being made to a fishing right by the deputy commissioner, and this is to be done every time during the resettlement periods. So if it is by the deputy commissioner, I think the appeal lies to a board of review and the basis of it. And so appears for you. None appears for the other respondents on board. The petitioners herein have joined together to challenge the order dated 15/9/2020, whereby whereby the private respondents have been also been included in the register to be maintained by the deputy commissioner in respect to the fishery locally known as Kinar Khal Nala of Moza Chandinagar, part Roman 6. And what is this? PH means?
Forgona matter.
Huh?
Forgona. In Barak Milo Tuzan, there is a Forgona, PH.
That I know, but why did it become PH? Okay, Pargana, lever putter. This court have duly taken note of Rule 14 of the Assam Fishery Rules 1963, which empowers specifically in the Kachar district to permit persons settled with adjoining lands or pertaining in relation to second-class fisheries, names to be entered in a separate register in the deputy commissioner's office, and a lease for such fisheries to be sanctioned in a special form at the time of resettlement. The petitioner claims that they have been settled on the ground that they have adjoining lands to the fishery in question. However, the private respondents also claim that they have adjoining lands and the predecessor of the petitioners have permitted them also to have fishing rights. And it is under such circumstances the impugn order was passed on 15/9/2020 by the settlement officer. The question as to whether the petitioners solely has the fishing rights on the basis that their lands they have settled lands adjoining the fishery in question, or the private respondents also have settled rights, lands adjoining the fishery in question, are questions of facts which can be only adjudicated before a forum, wherein such disputed questions can be adjudicated upon. This court further takes note of Rule 11 of the Assam Fishery Rules 1962, 53, which categorically mentions that an appeal against any settlement, an appeal lies to the learned Assam Board of Revenue. Further to that, the settlement which have been made, being a settlement made by the settlement officer, in the opinion of this court, would also encompass, in terms with section 147 A of the Assam Land and Revenue Regulation 1886. Both the provisions read together would show that an appeal lies before the learned Assam Board of Revenue. It is the opinion of this court that as disputed questions arise between the petitioner's claim to have the sole settlement, dehors the private respondents, whereas the private respondents as well as the respondent authorities claim that the private respondents also have a right to be granted the settlement, are questions of facts which cannot be adjudicated upon by a writ court. Accordingly, this court, therefore, is not inclined to entertain the instant petition. Liberty granted to the petitioners to avail remedy before the learned Assam Board of Revenue, if so permissible under law, and the period during which the instant writ petition has been pending, that is, with effect from
16/11/20.
You knew it beforehand. 6/11/2020 till date be excluded while completing the period of the petition.
I will take a provision for appeal, my lord, under some minor criminal concession rules 2013. This order can be appealed to. This for my lord principal conservator. Let him, my lord, decide as per the framework of regulating stone.
No, they have filed a super.
DFO.
You have given us super.
Yes.
They have filed a super.
I replied to the super.
So pass an order on that, we set aside this. Go ahead. This type of order this is absolutely not permissible. You go ahead and decide the super. Thereupon they will file an appeal. Against the suspension, if I allow them to go and file an appeal, that makes no sense. Here you have to have the basis. Yes, you could have said that look here, that these are the documents we have, you have not furnished any document, and as such it is not permissible. You cancel it or do what's talking. What is the suspension business on saying that you have not produced the document? You set aside this and take a decision on the support. You can very well do it.
But sets aside, how can
I set aside only the so-called this one, page 25. Only the suspension I am setting in. Allowing you to go ahead with the show cause. Is what I'm.
that
Heard Ms. Wenso, the learned counsel appearing on behalf of the petitioner. Mr. Ibotakur appears on behalf of the respondent number 1. The petitioner herein is aggrieved by the communication dated 30/5/2026. Whereby, without asking the petitioner what are the documents required, on the ground of non-submission of such documents, the petitioner's license the petitioner's right to right to carry out the operation of stone crusher unit have been temporarily suspended. It is a specific case of the petitioner that if the petitioner was informed about the documents informed about what were the documents to be submitted, the petitioner could have submitted those documents. And if there was a failure to do so, action could have been taken in the pursuance to the show cause notice. But without indicating what documents are required to be submitted, such action could not have been resorted to. This court have duly taken note of that on 19/5/2026, the petitioner was issued a show cause notice on the basis of an inspection which revealed that certain lands have been used for commercial purposes related to the petitioner's stone crusher unit. The petitioner thereupon submitted a reply stating inter alia that the 6 bighas of land the petitioner has set up the stone crusher unit. However, the petitioner using some other party's land for stocking raw materials, vehicle parking, etc., which are not commercial. And the petitioner in that regard are taking effective steps. To the surprise of the petitioner, the respondent authorities, the divisional forest officer, Lokhimpur division, by the communication dated 30/5/2026 impugned in the instant proceedings, have informed the petitioner that the petitioner have failed to inform the petitioner that the petitioner was required to submit the required documents at the earliest. Failing which and pending such submission of the documents, the entire operation of the stone crusher unit was temporarily suspended. This court, for the present, is not adjudicating as regards the proceedings pertaining to the show cause notice, which the divisional forest officer, Lokhimpur division, shall do so. However, it is the opinion of this court that without specifying what are the required documents, the divisional forest officer could not have suspended the operation of the petitioner stone crusher unit, inasmuch as the same would be arbitrary and unreasonable. Accordingly, this court therefore disposes of the instant petition with the following observations and directions. The impugned communication dated 30/5/2026 is set aside and quashed. Number two, the divisional forest officer, Lokhimpur division, shall duly provide the petitioner the details of the documents so required, and if there is and thereupon, if the divisional forest officer Lakhimpur division is not satisfied, shall proceed with the determination of the so-called proceedings in accordance with law. With the above, the instant proceedings.
May I pray for liberty to approach the High Court again, if at all required? May I pray for the liberty to approach the High Court again if required, after the
Absolutely no. You have a liberty as per appeal.
date for which?
May I please a motion? Second.
So you don't have a minister for social justice and recently he became. But otherwise he is entitled.
The file affidavit also. Affidavit already filed also.
Mr. The instant petition has been filed by the petitioner. Being aggrieved at the inaction of the part of the respondents in not releasing an amount of rupees 17,06,000, which is payable to the petitioner for the financial years 2020-21 and 2021-22. Today, when the matter is being taken up, Ms. R.M. Decker, the learned standing counsel of the Water Resource Department. Oh, you have social also. Social Justice and Empowerment Department submitted that the petitioner herein is entitled to the amount of rupees 17,06,000. And for that purpose, the proposal for financial sanction have already been submitted to the Department of Social Justice and Empowerment. The Departmental Finance Committee had also concurred with the said financial sanction proposal. However, as on the date on which the instruction was provided, there was no Minister of the Social Justice and Empowerment Assam. The financial sanction would be communicated to the Finance Department after the Social Justice and Empowerment Department Assam, after the portfolio of Social Justice and Empowerment Assam is being given to a particular minister. First, the said instruction dated 25/5/2026 is kept on record and marked with the letter X. List this matter on 10th of August 2026. In the meantime, as the respondents have duly admitted the entitlement of the petitioner, due steps be taken for the purpose of disbursement of the amount to the petitioner. The next date is fixed for an update.
Look, I have received the sum of 7,93,000 out of 8,07,000. only 14,160 is due, my lord, from the
Central government. Central government,
Yes, central government. My lord,
no Ministry of Jal Shakti. Mr. Jain, you are the most expert out here for water source.
my lord, I want to withdraw the, my lord, because entire amount has been paid, only 14,160 is.
You are not insisting. Okay, Mr. So and so, the learned counsel appearing on behalf of the petitioner submits that the petitioner have received nearly the entire amount, save and except an amount of rupees 14,160, for which the petitioner do not want to further pursue with the instant proceedings. Ms. R.M. Deka appears on behalf of the Water Resource Department. Considering the above, the writ petition stands closed on withdrawal.
Look, in this case, I was supposed to file a rejoinder. I'll file it next week, the coming.
What?
I was supposed to file a rejoinder in next case. So
When?
24, well, I'll file it next week.
Huh?
I was supposed to say, here we have
Effect-
only admitted 12,88,650. Paragraph 6 or affidavit, I kindly pay.
He's asking for 29 lakhs.
He's asking for 35 lakhs, 51,800.
He's asking for 29 lakhs. 29 lakhs, 88,200.
Yes.
And then you say that he's entitled to
Only 12 lakhs.
have received after payment was completed for a bill of so and so. With a prayer for found the file which was received after payment process was completed for the authority approved an amount of rupees so and so out of rupees 35 lakhs. And for final payment and only for final, and accordingly the amount was paid to the firm on 5/3. So you have paid the amount.
Paragraph 6, they say they don't.
Certain
You
amount
got
was
the
paid.
12 lakhs.
What's those?
Okay, remaining if you want to go before the civil court. Not here. Heard Mr. R.D. the learned counsel appearing on behalf of the petitioner. Mr. K. Gugoi appears on behalf of the respondent number. One, two, and three. 1 and 3. You are there. 2 and 3. Nirmala and Chaudhary, Nirmala Chaudhary appears for respondent number 2. And so appears for 1 and 3. The petitioner herein had approached this court claiming an amount of rupees 29 lakhs 88,000 along with interest at the rate of 18%, which as per the petitioner was not paid by the respondent authorities in spite of the petitioner carried out the supply orders. This court duly takes note of the affidavit which had been filed by the respondent number 3, wherein it is categorically mentioned that that a bill of rupees 37 lakhs 18,250 was received but was found in the file as regards the supply made by the petitioner. And out of the said amount, rupees 12 lakh 88,650 was the amount approved by the authorities. And the said amount was duly paid to the petitioner firm on 5/3/2021. Pusto. The said affidavit further mentions categorically the reasons as to why the payment have been less to what has been claimed on the ground of quality of the items, defective items, etc. In the opinion of this court, can, in the opinion of this court, and it is the opinion of this court as to whether the petitioner had supplied items which were of good quality or the petitioner had supplied defective items, etc. Are questions of facts which needs to be adjudicated in a forum wherein evidence can be led. The writ court, in the opinion of this court, would not be the appropriate forum. Accordingly, this court is not inclined to entertain the instant writ petition inasmuch as the petitioner, inasmuch as disputed questions of facts arise. Accordingly, the writ petition stands closed. However, it is the opinion of this court that taking into account that the petitioner has been relegated to the competent court of civil jurisdiction, the period during which the instant writ petition have been pending and had been pending ought to be excluded while computing the period of limitation. Accordingly, the period from 22/5/2023 till date be excluded while computing the period of limitation.
We have challenged this by way of this petition. We have challenged the jurisdiction of the IRCTC to issue the impugned communication, which your lordship will find at pages 31 to 36, lordship. 39.
What are you challenging? What do you want to say? Because this matter is some additional affidavit was filed on 9/6.
Yes, lordship.
What is that?
By that affidavit, I have placed on record that the petitioner firm, partnership firm, has paid the license fee for the 3 trains, Gauhati Oka, Kamakhya Gandhidham, Gauhati Barmer Bikaner Express, by way of the letter dated 25/8/25. That's at pages 511 to 514. And lordship, and then, but thereafter they have also handed over the 3 trains, the Penticar services. The pages 515 to 518. Meanwhile, my lord,
So you paid as per the existing rate. Only the enhanced amount you are on that.
well, my lord, there were few other communications which were issued to the petitioner firm to demanding the enhanced license fee during this time frame. Although the
Basic license fee, GST, this is at a higher rate, 511.
no, it's at the existing rate.
Is it as per the existing rate?
Yes.
No, but you have challenged the revision of the rate. Is this rate at 21,19,601? Is it the existing rate or the revised rate?
Existing rate.
So this is along with this. And net paid payment also these are payments. This is as per the existing rate. All these payments have been made. Now, what are the instructions? What they are asking for?
Now, during this time frame, few other communications were issued to the partnership firm demanding the enhanced license fee, which I wish to place it on record by way of an additional appeal.
Why? Why didn't you file it together?
The authorized signatory was not in town.
That authorized signatory was very much available when the additional affidavit, this additional affidavit could be filed on 9th of June. And then why you could not file it now? The matter has come up only on 12th. So on 9th, he was very much available. And why today you have not, you are making this, we reject this prayer. Anyway.
Shall allow me to file those.
No, I can't. Now let us argue the matter. We have already looked into it.
Because only then, otherwise.
No, we can't because it is a time taking time. We then vacate the order. It's very clear. You can't come up with this type of pleas. It's a very, first of all, that person you say is not available, but he was very much available on 9/6.
Yes, leave.
So you got it. Are you telling me that on 10th or 11th you got these documents?
They will be aware of it.
Not you. Were they not aware at that point of time? I'm not with the council. I'm with the party out there. So you can't take up adjournment on that basis. Anyway, that is besides the point. Whether you are entitled to as per the old rate or as per the revised rate, whether IRTC has the jurisdiction to do this, this is the question.
Yes, Lord.
So we only need to repeat that. Let us hear you on this aspect. Why you say that it is not? The issue involved in the very is as to whether the IFA has been empowered by the railway to revise their license. That's it. What do you say, railways? You are the main person. Huh?
I'm not here on for you.
So they, where you stand? Because they are saying that it is the central government who can do it, not IRTC. This is their basic case.
Yes.
It's the long and short is that. So therefore, I have recorded it last time, if I'm not wrong. Heard the matter and is of the opinion that the interim order which has been passed earlier requires to be modification. And direct that no coercive action shall be taken against the business subject to the petitioner depositing the license fee before the IRTC at the rate which was in existence prior to the revision being carried out within 15. The modification is done to the interim order. That in the circumstance petitioner have already made the payment of the license as per the rates prior to no course of action shall be taken against them. This is matter on so and so, observe the present orders take part shall not be done in any manner that is quoted passed in direction for renewal of the license or creating any right. That is one. Now my question is whether the claim of the petitioner seeking extension in terms of have been rejected by the court, by this court also affirmed. Either they give me while the proceedings pertaining to the renewal was going on, the petitioner by way of the present petition was raised the issue as to whether the IRTC has the authority to revise the license fee. We realize that in terms with the Indian policy, the power is only there with the railway. The petitioner had therefore essayed the circular dated demand IRTC, the demand dated demand as well as the demand prayer by way of the present proceeding. By the order directed that there shall be no so and so. So you are the main person. No. Email is okay. Whether the power to revise, because they claim that look here, we were the existing lessees of as per the catering policy of 2010. We have been granted an extension on the basis of the catering policy of 2010. Now, the catering policy of 2010 states that the power is with the railway. Now, unless the railway had empowered the IRTC specifically that you can increase the rate, IRTC has no business. Last time I still remember when the matter was taken up, you were there. Yes, you were there. I put the specific question when somebody made the submission. Oh yes, Mr. Sayawala made the submission along with you. That look here in the affidavit, in the agreement, they duly agree. My question is whether in the agreement they agree is a different aspect. The question is as to whether the IRCTC has the authority to do so. That is the substantive question to decide. That is the only issue. You are the main person to say, not IRCTC. No, IRCTC is only a delegate. They don't have their own right. The right is with you. Which one is the tripartite agreement?
23, Lordship.
Page 192.
223.
223.
Lordship will come to page 224.
Okay, this is between an agreement between railway is there?
Yes.
Railway is there. IRTC there, Deepak is there, where the ministry have announced a catering policy has been mandated to carry out unbundled by creating a distinction primarily between food preparation and food distribution. Whereas as per the policy, IRTC shall be responsible for management of catering and so and so. Whereas NF Railway shall reassign the contracts of mobile units so and so on the same terms and in pursuance of the direction of the policy so and so taken over as so and so shall continue to provide so and so for a period of license awarded by so and so, hereby assigns its rights and abilities as licensee for acting under so and so the terms and conditions. Or these authorized officers will have the power to inspect the claim and have the power to terminate the CMD. What is CMD?
Chief Managing Director.
Managing Director,
IRCTC.
Have the power to terminate the agreement in case CMD so and so shall continue to have supervision and monitoring. CMD shall receive IRTC so and the license fee with effect shall be paid to the so and so. Shall have been paid in advance in the continuation of the year. Shall be from in case of any dispute. The matter shall be referred to arbitration to a sole arbitrator to be presented as arbitration as mandated. So that's it. As regards whether it can be done or not, how do I know? Do you guys the charges?
They are only tested in 4060. 4060, that is there. The railway.
Page?
In the page 224, 8.5.
For the unit so and so awarded by NF Railway on Iman and reassigned to license fee shall be shared between NF Railway and EI in the ratio of 40-60 respectively on the date of handing over the unit to IRC.
And moreover, as per the, because here license fee is enhanced only because the tariff has been enhanced. On the basis of tariff, my lord, it is fixed. As per the 10 policy also, 159, you will also see, my lord, that it is there. As per the it is there.
But tell me,
Yes,
whether
and-
they can do it or not,
So,
how
my lord,
much would be
here
the
accept-
license fee or not?
My lord,
These are questions of arbitration, madam. Why should we entertain? You have an arbitration clause.
Already similarly situated
Forget about us, similarly situated.
cases, these letters were on, which has been assigned before your lordship, that the subject matter of challenge in those has been clearly held by the arbitral tribunal in favor of the claimant. That
In favor of?
the claimant,
Fantastic, go there.
Lord, all I am praying
No, you go there.
that we place those.
No, not necessary. You go to arbitration. This is a clause 8.9. Why should I decide? Arbitration clause. Here is the issue as to whether as per the tripartite agreement, it is the arbitrator who is the best judge. This court cannot decide or interpret the terms of the agreement. 226, not possible. It is the arbitrator who is the master to decide interpret the terms of the agreement. So here the question arises as to whether the IRTC has the authority to revise. This power is very much there. So very on. Arbitrator will decide.
Lordship will also come to the.
Has anybody gone to arbitration?
Other,
Many
other.
cases has gone, my lord, from in favor of the IRCTC and few, my lord, against the IRCTC, where we have section 34 bits.
Then, very well, everybody has gone on this issue. Now, heard me speak further the learned senior counsel assisted by students who are appearing on behalf of the petitioners. Ms. Swens, Mr. Greer, Mr. Greer, Sahavala, the learned senior counsel appears on behalf of the respondent numbers 3, 4, and 5. Mr. H. Gupta appears for 1 and 2, to Milari. The present proceedings raises a question as to whether it is the railway board oblique the NF railway or no, it is the railway, no, it will be the railway board or by the NF railway.
Railway board.
As per you, the railway board. As to whether the railway board, how will the railway board do it? Huh? This phone number? We don't have 7, we have only till 5. No, I think it will be the railways. The railway or it is whether it is the railway or the IRCTC would have the power to revise the license fee. Full stop. It is very pertinent to take note of that the petitioner in the instant case was initially granted the license. Was granted what is that license or what? The license for providing catering services in 15635/36 Gauhati Okha Express. That is only one.
There are three lordship. Gauhati Okha, Kamakha Gandhidham.
Yeah, you ask your junior to give the date. Huh? So and so and so and so and so and so. Under the catering policy of 2010. Subsequently, in terms of the catering policy, an extension was granted.
Extension was not by the railway, madam. We have granted.
Understood. It is on the basis of the catering policy, you have granted an extension of 2010.
No, 17.
17 does not permit extension, Mr. Counsel. Don't come up with that. If you make that submission, it will go.
I'm sorry, sir.
Don't make the submission. The petitioner thereupon was granted an extension specifically taking into account clause 17.5 of the catering policy of the year 2010. At the time when the extension was to be granted, the catering policy of 2017 had already come into force. Resultantly, and post, in terms with the said catering policy of 2017,
Extensions are at page 228, madam.
IRCTC was mandated to carry out unbundling by creating a distinction between food preparation and food distribution. And further, IRCTC was made the sole responsible for management of the catering services through the mobile catering units, base kitchen and other kitchens unit, these cell kitchens, refreshment rooms at AI and A category stations, food plazas, food courts, train side vending, and Jan Ahara. It is under such circumstances. There were three tripartite agreements. No? Three tripartite agreements were entered into by and between the chief commercial manager, NF Railway, DES PM and catering, NF Railway, with the Indian Railway Catering and Tourism Corporation Limited, IRC, and the petitioner. These three tripartite agreements are dated. Where are those? One I have got in 223 and others.
I have a next one. Only one such agreement.
Why haven't you enclosed others? So only in respect to one will pass. We won't consider the others then. It's outside. Because, huh?
I'll place some record into this.
What?
The other tripartite.
No. You have it? Copy with you? So no, we will only go as per that. Only one bullion. Have you mentioned in your petition? The G. You have only referred to one. Huh?
Yes.
Only this. So we'll consider with this one. This petition is only in respect to this. A tripartite agreement was entered into on 6th of October, so and so, between so and so, so and so. In the backdrop of the above, it is very relevant to take note of that the said tripartite agreement, it is relevant to take note of clause 8.9 of the said tripartite agreement dated so and so, 6/10/2017, which is reproduced here in under page 225. From a perusal of the above quoted clause, it would be seen that if there arises any dispute, the matter is required to be, the dispute is required to be referred for arbitration to a sole arbitrator to be appointed as per the Arbitration and Conciliation Act 1996. The dispute in the instant case, as aforementioned, is a dispute as to whether the NF Railway or the IRCTC would have the power to revise the license fee.
So extension was at page 6, that's my also saying that. Extension. At page 6.
License,
Yes. Because we have
the same dispute. Is the said dispute, the said issue is a dispute coming within the realm of interpretation of the tripartite agreement dated 16/10/2017. And as the parties herein have duly agreed to avail the alternative remedy of the arbitration, and the parties herein duly agree as to whether for referring such dispute to arbitration, this court do not find the present case fit for entertaining the instant writ petition. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The parties herein are granted liberty to avail remedies in terms with clause 8.9 of the tripartite agreement dated 6/10/2017. Number 2, this court have not decided as regards as to whether the NF Railway or the IRCTC would have the authority to revise the license fee. The same shall be dependent upon such adjudication to be carried out by the arbitral tribunal to be appointed in terms with clause 8.9 of the tripartite agreement dated 6/10/2017. Number 1 to devote, this court, for the reasons aforementioned, this court is not inclined to entertain the instant writ petition. That's number 2, two parties are liberty to answer. The petition stands closed.
There was page 230. That's the renewal of contract.
Page.
230. For Kamakya Gandhina, the renewal that we did.
Where is the tripartite agreement?
Renewal.
Now, this is for 2019. When did this happen? The revision?
The
Revision in the page 226, Okha, we have mentioned here that in case of revision of catering tariff, the license fee payable by OISTC shall be varied based upon the prorata from the date of revision.
No, we can only, this court will only take this matter as only one matter.
Yes.
Only for this Okha.
Okay.
We can't take up for others because that agreement is not clear, na?
Okay.
What is the prayer? Let us see. 2017. Issue a challenging. Yeah. One thing is here. I think we can bring the other. Did you have the tripartite agreement with the others also?
I don't.
There are 3 other trains, na?
Yes.
Because this is the bill which is there, because otherwise we will be in trouble. You have a copy of it?
Not right now, but
Okay, then we only consider this, the other is dismissed. Huh?
week's time, let me
10 till 4 o'clock. 4 o'clock. Ask them to provide that, only that, then we can insert it. 4 o'clock. Then we can insert, otherwise you will be in difficulties.
might be 4:30 as well. That accommodation.
I normally sit till 4:30. But because these are 3 things, huh? 15632, 15636, and 15668. So we have only one, that is a 223. Baki kita sekarang.
Petitioner claimed 70 losses. Yes, our record 74 lakhs losses. More than their claim loss. In affidavit loss.
Please.
The construction loss, here the not vehicle loss, the construction. Page 19 मालूम में kindly.
So yes, for this. So paragraph.
Paragraph 5 loss.
5(2). I put this paragraph 5.
5 and loss.
5 and
11 loss. 10 and 11 also loss.
Not necessarily 10 and 11.
Because 10 was only 5.
5 will do.
5 will.
So, a police officer. So first we direct that this amount is to be paid, one. Second, if any amount has been paid, it will be set off.
Loss.
And when you pay bill, make necessary deduction as per.
Loss.
This is police. Supposed.
Always loss.
Put the name of the council is not there, but.
Always.
Well, I express my apology for not being present in the last occasion.
Huh?
But I was not present on other occasions. Since I missed the matter and I overlooked the matter.
Yeah, then
Today,
I was about to appoint a legal aid counsel. Taking into account that you have paid to appear. And there is a requirement of the matter to be taken. What is the case?
Your Lordship, the petitioner has returned from service on 28/2/2013. He has not been paid the retirement benefit as well as pension, has not been determined till today.
They filed an affidavit. Have you replied?
Yeah, that has to be replied, Your Lordship.
Why haven't you replied
Your Lordship, the
after the petitioner dies?
no, Your Lordship.
Then why haven't you replied? This was filed in the year 2025. First of all, you don't appear when the matter is called. Second of all, you don't reply after even 8 months. They have denied.
No, they have not denied. The bank has.
Huh?
Respondent has not filed their affidavit. Respondent of the bank.
Who is appearing for respondent?
Respondent, they are the main respondent, Your Lordship.
Who is
EPF is
appearing?
the one who will give the pensionary benefit unless after the amount is deposited by the bank to the EPF. Your Lordship. That's why pension could not be determined.
Now, who appears for the industrial cooperative bank? Now they have a proper branch. The problem of the administrator and all these things is over. Why haven't you made the managing director of the party, the party?
Your Lordship, yes.
What is this administrator business?
Your Lordship,
They have a chairman also.
Chairman is there.
Where? You have not made him
So,
a
Your
party.
Lordship, is the managing director who the person who deals with that?
Where is the managing director in that page 5 of your petition?
That time it was administrator, Your Lordship, when I filed to the administrator. At that point, the bank was taken over by RBI. The administrator was appointed, Your Lordship.
Then?
Now administrator is not there, Your Lordship. Bank was represented by administrator at that point of time. Because the RBI was to appoint administrator for 1 year on and that way you have to. So that's why it was run by the administrator. Even the bank is still closed now. People are not getting money out of your accounts are frozen.
I think no, bank is appearing now. They had
Yeah,
the
because
election
some-
and now they're
some
upon it. You are
possibility
the
is there.
corporation, you will be knowing it. Nowadays, I think they had the AGM. And they have now,
Someone is agreeing in this matter, so other matter also, is standing counsel.
then, where is he? They have taken very lightly, like the petitioner council.
Reflected as thus R two, but in the call is reflected as the first two, reflected, but not SC or the bank. Therefore, I think he has missed the case.
Now the administrator has no business out here.
Yes. And the petitioner have to impute the MD.
But they don't have MD also. MD is not there. MD is also not there. There's no MD.
MD was there.
No, he was not. MD was arrested. He was for bungling. He was arrested.
Some.
No one MD.
No, now they have a new chairman.
Yes,
New
yes.
chairman is there.
Then they may have to make chairman as a participant here.
See, madam, the responsibility now is of the court, taking into account that the petition is 71. Council have not filed their reply. All these things was their duty to be more vigilant. Yes, 35, 60, 40, 45, 50, 55, okay. This court can be very lenient on that. But this is the page the person is 75, 71 years,
Yes.
now is 73.
Yes, I have seen my.
Now 73 years old, if he's now fighting out there and the court is not picking up the matter, then. So it is my responsibility rather than the responsibility of the council.
Hello, so we can take
You
the matter after
want
some
it-
time.
You take it, we do want it one day, we have it next week on Monday. You just find out whether the industrial cooperative bank is running how.
Lordship,
We'll impede it.
my lord. On Monday, lord.
This matter on Monday, I will give it on Wednesday.
Lordship.
This matter on 17th of June 2026. In the meantime, Miss MD Bora Talale, Standing Council of the Corporation Department shall apprise this form as to what is the present status of the industrial cooperative. What is that bank?
Industrial Cooperative Bank.
Bank Limited. And the respective officials in charge thereof.
Lordship.
You can get it done.
Much. Obvious.
May please, your lordship. The petitioner has applied as per the application of the responsibilities for allotment of retail outlet of petrol pump in a certain location in Chinchua district. What has happened? As per the browser, we need to have executed a lease deed. In the lease deed, well, there is one mistake, important mistake. It should be 17/10/23, but it was written on 18/10/23. On the same date, it was rectified. On the same date, it is on page 130. There is certificate given by the sub-register office, and thereafter he was provincially selected. And thereafter, due to some importance, this page number 3 was uploaded, mistakenly uploaded. Thereafter, he was the responsible officers disqualified, saying that he is not eligible without compliance of section clause 14 E and 14 E, page 49. Page 49. after the married.
What is this lease deed at page 114?
And this is the lease deed. All of the facts here are similar to your lordship's order in Jyotsna Chaudhary.
They had a different, there was a page difference.
There was
Yeah,
a page
there-
difference.
there was-
Here also, my lord, the lease deed was dated as per the petitioner, which is effective here, was 1710. And the lease deed which was submitted to the IUCN was 1810. Now, there's another aspect that your lordship will see here, madam. That in that case, Jyotsna Chaudhary, my lord, the 1/4/2024 issue, my lord, was after the date of the advertisement. In this case, the last date for application of the advertisement is 27/9.
So lease deed is subsequently.
My lord?
Lease deed is subsequently.
No. The lease date is within time.
What is the last date for submission of the application?
The last date for submission of the application, my lord, is 27/9. 27/9, my lord will kindly come to page 24. 24. That is the last date of submission, my lord, 27/9/2023.
Okay, where's the lease deed?
The lease deed, my lord, starts at page 114, my lord. 114.
It is 1710.
1710.
So it is much after.
No, 1710/2023.
And what is the last date for here?
Submission, my lord. Yes, it's 1810.
It is last date is 27/9.
Yes.
That is what I am saying.
That is a different. That
The
is.
date of the
Yes.
last date for submission is 27/9.
Yes.
And he got the lease deed subsequently when, at the time when he submitted the application, there was no lease deed.
No, my lord, that is,
So that is the difference out there.
that is the crux of the matter.
Your lordship, see the impugn order. I was rejected only because that deed was not supplied on 1710. Not for this. It is on page 152.
Yes, where?
Page 152. May I read? Please refer to your application that received by us for application number, form number so and so, dated 17/10/23 on the subject. It is observed that the land documents submitted by you along with the applications are not valid for considering the afforded land under Group 1.
Now,
For
you
reasons
mean
as
to
stated
say,
below.
Mr. SR Gogoi, you want to say that the reason assigned is not the reason now Mr. M. Sharma is campaigning.
Yes.
He is saying that as on 27/9/2023, you did not have a lease deed at all. So therefore, that lease deed cannot be taken into consideration, rightly so. It is only if it is a case where there is, it comes under this particular clause, only thing which is permissible out there is this.
My lord, page 57, my lord. List of non-rectifiable deficiencies.
That is there. Again,
Because according to my instruction, the date of last application is on 17/10/23.
when did you submit your application?
As per my information, this last date is on 17/10/23. In their affidavit.
He has submitted his application on 17/10. Only see 113. Submission is wrong.
Yes, my lord, 1710.
So the last date is not 27/9.
that is not in the part of, because I'm not aware of that. The last day, apparently it has been extended. If the lordship grants in 5 minutes.
Obviously, it is
It
apparently
seems that-
from there,
It seems
the
that, my lord,
moment you are taking his application of 17/10/2023,
it cannot be beyond that. Yes.
means you have duly taken into account that said aspect that there is an extension, otherwise how will you put him in category one?
How can I upload? There ought to be. There ought to be an extension. Also, my lord, the category one is based upon initially the filing of the application and then the documents are received.
That I
So,
know.
But this
So
date,
therefore 17/10 is.
this date proves that.
Now, if 114,
My lord.
kindly see this particular clause,
17/10, my lord.
kindly come to page 118.
Yes, my lord.
To the demise unto so and so for a term of
30 years.
30 years commencing from 17/10.
17 October.
Then-
If that date has been extended from 27/9, then
That, no, in fact, that is never your case also in your notice.
no, but that round, my lord, will be as per the terms of the tender, my lord. But again, if the date has been extended, my lord.
No,
then
first of all, then how, if he has submitted his application on 17/10
then, ma'am.
and you have put him in group one,
Group one.
means
it
that you
implies.
have
Yes.
automatically extended.
True, ma'am. That means it's extended, my lord. I was not a part of the council that point in time, but this is.
Now, why it is 17/10? How do you take care of page 118?
My lord, in fact, this issue which has happened is that the,
Produce the original of this document.
my lord, page 130, I think the petitioner has tried to substantiate his case. Page 130.
The 130 is the certificate claimed by the
Yes.
sub-register.
So, but in any case, you will also direct them to produce a copy of the original.
On the same date, it was rectified.
So therefore, let us see the original
My lord, my lord, my
and it will be covered by my judgment.
lord. And I'll also get instructions, my lord, on that because my.
No, 100% it has to be,
Has to-
otherwise how, because he submitted his application on 17th.
True,
Okay. Mr. S.R. Gogoi, who appears on behalf of the petitioner, is directed to produce the original of the lease deed dated 17/10/2023 before the court on the next day. The Mr. M. Sharma, the learned counsel appearing on behalf of the IOCL, is also directed to obtain instruction as to whether there had been an extension of the period for submission of the applications, bids. More particularly, taking into account that the petitioner's application is dated 17/10/2023. List this matter after vacation.
Since, my lord, there is a stay, if subject to your lordship's convenience, since it will be only pursuant to.
Next week.
It's otherwise covered by my other.
Jyotsna Chaudhary, my lord.
List this matter, okay, we finish it off on 23rd of June.
23rd, I'll be outside. On any day.
Any day you say which is convenient to you, this court will otherwise also sit on a Sunday if you want. Oh. Not possible. After vacation. Whenever it is convenient, when? After vacation.
Any day. Any day on 15 or 16.
You hang me.
After 19, I'm going.
But what will happen now? 2 years have gone. Now he doesn't have the qualification.
Your lordship will observe that.
He doesn't have the qualification. His lease is not 19 years now.
Actually, it is 30 years.
30 years, my lord. The
30
lease
years is
period
30.
30. Now it
30 years.
will be now 28 years, my lord.
So there is time. We'll have it next January. On 4th of January 2027.
I'll say the short date, my lord. I'll leave it here.
Interim order not extended. Do whatever you like.
Lordship, is a lady, of ST category.
What?
Petition is a lady.
So what?
ST category.
I don't have differential treatment. Article 14 applies to men, woman, child, everything. So how does it matter?
Fix a date. On any date.
23rd of June.
Mass oblige. Also, interim order may be continued.
Interim order passed the issue.
The respondent authority is supposed to file their response, madam.
At 22nd polling. Yes, Mr. Gogoi. I put it on 22nd. Get the original. Yes, what is it? Non-payment.
In that case, we need some time, Lordship.
Huh? For what? Why haven't you been paid?
Our claim is that she is entitled for 25,57,471 Lordship. Already getting Lordship amount 11,11,655 Lordship.
She's entitled to.
Yes,
Already-
already received. Lordship.
Already received. I am before lordship for 25,57,000.
Out of that, 11 lakhs you have received.
No, Lordship.
Out
Out
of
of 36,69,000.
You've got 11 lakhs. And do you admit to the claim?
No, Lordship. I have yet to receive instruction, Lordship.
Not received. Which department?
After vacation, Lordship.
Social welfare. Department.
Social. Well, which? Women and child welfare.
Lordship. Lordship.
Social welfare is now social welfare or social empowerment. Hmm? Do you have the
It's a bypass.
women and child welfare department now? That will be by the social justice.
Yes, sir.
Then Miss R.M. Deka will be appearing. Different council. Get hold of her. You give a copy to her. The petitioner herein claim that the petitioners are entitled to an amount of rupees 25,57,471 from the Women and Child Welfare Department of the Government of Assam. Isn't that now social justice? The state department has been, the nomenclature of the state department has now been changed to social justice and empowerment, na? Right? Social justice and empowerment department of the government of Assam. And Ms. R.M. Deka appears on behalf of, is the standing counsel of the state department. The counsel appearing on behalf of the petitioner is directed to serve a copy of the instant writ petition along with a copy of the present order to Ms. R.M. Deka. To list this matter on 10th of August 2026, on which date the respondents shall apprise this court as to whether the petitioner is entitled to the amount so claimed in the instant proceedings. What is this?
Lordship, this was regarding the change of constitution from partnership to
What
proprietary.
happened?
I have submitted the affidavit as per order, as per last order by your lordship.
We don't have a case. Without a challenge to clause 1.5 H and J, not possible. I've written it very clearly in my last order. Read it, look into it, if necessary, consult another petitioner in person. You have a friend, na? You have another petitioner in person. He's an arbitration expert.
Yes.
Consult with him and then proceed.
Your lordship, this is as per that procedure. I would request your lordship to come to the page.
No, my question is, you see, question therefore arises is whether the petitioner here is entitled to be enlisted as per the proprietorship firm without submission of document, which is required in terms with clause paragraph 1.5 H and J of the manual of contracts.
I have submitted the required document, your lordship, and the G and
Not
H.
here, not here, there.
Yes, I have submitted there, but
When?
regarding G and H, your lordship, I would like to enlighten you, your lordship.
No,
That this letter,
I'm only with H and J.
your lordship, just page 46. Only this letter was returned to me. Where there is outstanding amount of 68 lakhs, which is factually wrong. So your lordship, come to page 47. It is that the submitted by the respondent to the arbitrator, the amount has come to 22.79 lakhs. That is the submitted by them. And in this letter, there the only 2 points was given. That one is there is outstanding standing,
Now,
outstanding amount.
where is the manual?
Lordship, page 28. Page 28 in of my affidavit. H. Affidavit from the contractor that there is no government dues recovery outstanding
Affidavit
against
of mayor that there is no government dues recovery outstanding against him. If there is any dues of anyone in this year, they will not be carried out.
This letter was included only in their petition, reply in petition, their
And
reply in
J,
a
affidavit from
opposition.
giving a brief of the arbitration litigation case he is involved in. Okay, you have done as per J.
Yes.
So H is as to whether that is a subject matter of consideration. That will be decided by the arbitrator. Therefore, you have J. You cannot go for
But
that.
the affidavit is not yet been filed by him that there is no dues.
Your lordship, this letter was never
No,
returned to
no,
me.
No, the question is as to whether if the matter is pending before the arbitrator.
Here, after his application, lordship, not now. When he had made the application, that at that point of time, no arbitration was pending.
Now it is pending.
Now it is pending.
So therefore, let him file an affidavit to that effect as
Not
regards J.
Your
That
lordship,
was not
at that time also there was a arbitration was going on, petition was going on. And here I want to, even I have given your lordship.
Not this arbitration, but
This,
other degrees.
your lordship, just a minute, this.
Mr. Counsel, Mr. Petitioner in person. This. Here they are saying that H and J are not being complied with. H and J are different aspects. One is when there is a due payable. And the other is when there is an arbitration pending. Now, in this arbitration is pending pertaining to a case for so and so. While in respect to if both of them can be read together, you don't need to give an affidavit. You may very well give an affidavit to as per H that an arbitration is pending also.
Lordship,
And J also the same affidavit.
that's why my submission is that this letter was never addressed to me. This letter came to in the petition, in the reply in the filed by them and by respondent. This letter was never addressed to me. So how I will reply it? Here they have.
Now what do you want to do? What do you want to do now?
I may be directed to submit the. this
Why
letter
should
to
I
you.
direct you? You are at liberty.
No, your lordship, they have not returned to me that these are for due to which these conditions.
Now you have come to know, write a letter, forwarding letter and do it. Now you have been able to appear
Your
before
Lord-
the court. So these people are much easier to deal
No.
with.
Your lordship, page 43 in reply, number
Fine.
2, I have said it is submitted that from the above arbitration, there are 2 more arbitration under proceedings, namely MKB 01 and 2.
You do one thing,
Appointed in arbitration.
Mr. Petitioner in person, you do one thing. You go and give whatever document is there, then we'll look into it by submitting a representation. We'll look into it then. Taking into account the affidavit in opposition file that the petitioner have not been able to comply with clause 1.5 H and J of the Manual of Contracts 2020. The petitioner in person submits that he would submit a representation along with the required affidavits within 15 days. List this matter again on 10th of August 2026 for an update.
Your lordship, here I want.
If such representation is being submitted, the respondent authority shall duly consider the same within the ambits of law.
Your lordship, the owner's time to file reply in the affidavit process. The affidavit in opposition filed by the respondent number 4.
You want to file reply?
So will tell us.
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits. To the petitioner, that is in 643. And what about 644? What you have got a stay? What stay is this? Why should we stay? You have to pay the 79 lakhs, 79,200. Why haven't you paid?
The lordship, the against the increase of the rent lordship in the Howley under the Howley municipal report lordship.
Huh?
Howley municipal report lordship. All the petitioners shopkeeper lordship. The earlier lordship, they are increased the 5% to 10% lordship. But they are the increase the huge amount
Who
lordship.
appears for Howley? No, somebody is appearing in the other matter. Why the other matter is there? No, there is a matter out here. Here is which department? Howley. Yes, Howley. Somebody is appearing for Howley. I see. So why you are not appearing in this case? One is the 6788.
Both the cases are same.
You are filing going to, in one case you have filed affidavit? No. You are going to file affidavit. Mr. K. Kunta appearing on behalf of the Howley Municipal Board in both the writ petition submits that they would, that he would, that the Howley Municipal Board would be filing the affidavits. Taking into account the above, list this matter on 27th of July 2026. In the meantime, affidavits be filed. Interim orders so passed earlier in those petition, in one writ petition in all.
Both petition are same lordship. The 31 is
Interim
the
order passed earlier shall continue till the next.
Alia might have their final activity.
What is your case, madam?
Lordship, the husband of the petitioner, your lordship, receipt of the extraction of stone on the whole mahal, which affect from 2
What are you challenging?
Lordship.
18/2/2025. Where is that? Anyways, good. Government is not appearing. Good stuff. None appears on behalf of the respondents on call. Neither the respondent or his department have also filed an affidavit. In spite of a final opportunity being granted. Considering the above, list this matter again on 18th of September 2026. Interim order passed earlier shall continue till the disposal of the writ petition. What is this?
lordship, the private respondent has filed an affidavit. I'm seeking a recommendation to file and join the lordship.
What affidavit? What is the matter about?
The lordship, if I may say the facts.
No, don't say the facts. What is the matter about?
Lordship, the facts are essential also in just 2
What is
minutes.
the matter about?
Lordship, the
You are
matter,
challenging what?
matter is now pending before the labor court. However, the labor court on the framing of charge. But I will, if I give you the background, in the meantime, disciplinary proceeding has completed, Your Lordship. There are too many rounds of litigation between the High Court and all. So if I may just say the facts, Your Lordship. So, Your Lordship, what has happened is that a charge sheet was
You are
issued.
challenging what?
There is a application file without.
Which order?
Your Lordship,
Which order are you challenging?
page 66.
Page?
Your Lordship may see the petition first.
No, what order you are challenging?
64.
Page?
So 66. The second para.
Wait.
Without any reason, Your Lordship. On the same date, without giving us the opportunity.
Journal seen the petition bearing filed by paying before this court seeking adjournment for examination or
The second para I am challenging.
also seen the petition filed by working paying the on consideration on the petitions were also allowed. Then
Your Lordship, Your Lordship, he is the disciplinary authority who has passed the order. How now can he give an evidence on the same
I'm not
day?
on that.
Huh?
That is a different thing. You have, somebody has
No.
asked that, no, absolutely no.
Your Lordship, see the petition. Your Lordship, petition was filed on that day itself.
So what?
Your Lordship, without any stating reason.
Absolutely.
Order
no.
16 has not
No,
been complied with,
sorry.
Your Lordship.
I am not going to interfere with this. And you are lucky enough, somebody has passed the
No, no.
stay order. A labor court matter is being stayed. Have I heard of it?
Your
This
Lordship,
is there. We impose a cost upon you as well as the client of around 1 lakh each.
Your Lordship, just.
No, absolutely no.
Your Lordship will see. the
Heard
petition.
Mr. R. Sharma, the learned counsel appearing on behalf of, whatever you have to say, say.
I was not
say.
given opportunity, Your Lordship.
Absolutely not necessary.
On the
We are-
same date.
This court is not going to look into this.
Petition was filed on 20 February, Your Lordship.
So what?
I was not given time to
So
object.
what?
also.
You can object whatever you feel.
Like,
I am
was
not going
given,
to.
Your Lordship.
Sorry.
Then Your Lordship just give me liberty to file objection there.
No.
So Your Lordship will see the petition. Your
You
Lordship.
file review. Go file
Petition
review.
page 173, Your Lordship.
Whatever you do, I'm not going to touch
Lordship,
this.
just 1 second. 173, Your Lordship.
You
173.
you can only make one submission
Yes.
that look here. I don't want to press this petition. I will file a review. That's all. Nothing more. That is the only
Okay.
thing I can permit you. Nothing more. That's submission. My goodness, how can a labor court proceedings be stayed?
Yes, I will. I am agreeing to that, but for your Lordship benefit, just the facts.
Absolutely not. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner. So and so appears on behalf of the respondent number 4. And Mr. K. Gogoi appears for the respondent number 1, 2, 3. Why are you making all these people a party?
Not necessary.
Just to get it delayed. My goodness, in a labor court dispute, you are making all these people a party. Appears on behalf of the respondent numbers 1, 2, and 3, and Mr. So-and-so appears for the respondent number 4. The petitioner herein have assailed the order dated 22/2025 passed by the learned presiding officer, Industrial Tribunal, Gauhati, in reference case number 5/2022 on the ground that the learned Industrial Tribunal, Gauhati, have allowed the applications. The petition numbers 21/2025 and petition number 20/2025, both filed on the same date without granting an opportunity to the petitioner to object to the petition number 20/2025. It is the settled principle of law that the labor court disputes and the disputes before the industrial tribunal oblique the labor court are required to be decided at the earliest. More particularly, if there is a delay, there is a likelihood that the workman, what is that word used in that by the Supreme Court? In that case, I think we need to mention this so that his application there also is rejected. No?
Your Lordship, may I hear the facts?
Absolutely no.
Your Lordship,
Sorry, no, I'm not going to. Only if I hear is 1 lakh cost performance, then only. Otherwise, no. Let me put this. What is that judgment out there?
because
Anyway, no, Simon. It's the settled principle of law that the proceedings before the labor court or the industrial tribunals are to be decided at the earliest. In as much as if there is a delay, there is all likelihood that the workmen would lose his would not be able to cope up to the pressure which he is already suffering on account of. Here's a case of termination.
that's no termination. No, Your Lordship, the reference is not on termination. That's what I want to just. If Your Lordship bear with me, just the facts.
Absolutely no.
Your Lordship, what has happened? After the termination, he has filed a writ petition on the charge. And therefore, there was a reference. Reference is now on the charge. On the charge.
What?
This reference is on the charge sheet. Whether the charge sheet is justified or not. After the termination, he has filed a section 2A petition which he has withdrawn. He has challenged the terms of reference. Before this, he has withdrawn. Now, whether this will remain or not, that is an issue. Because reference is on charge. That reference has been formed after he has been terminated by a disciplinary authority.
Use the
After the inquiry report, after disciplinary authority has thereafter.
and
he
what
has-
order of 10-12 you are challenging?
That amount, Your Lordship,
There has been 18th of subsequent ground writing on the remaining. You have not paid that also.
Your Lordship, no, Lordship, hear me out, please. No, Lordship, please kindly. Lordship, that is till retirement.
Absolutely not.
It cannot be till retirement. We have paid till his suspension, till his dismissal. This is termination. We have paid 7,68,000.
Where's
And-
the terms of reference?
Terms of references. That till retirement cannot be paid.
Where's
Your
the
Lordship.
terms of reference?
That is by an court order. I mean, just
What you got? Whether the charge of misconduct against the workman is so and so is justified or not.
but that is framed.
If not, whether the workman is entitled to only relief.
Yes. Lordship till
In as
retirement.
much as if there is a likelihood that the workman would be out down with the pressure of the said procedure. It is also the opinion of this court that if there is any illegality in the proceedings, the petitioner can very well assail the same in the yeah. The learned counsel appearing on behalf of the petitioner submits that there being a procedural error committed by the learned industrial tribunal, the petitioner would not like to press the instant petition. However, the withdrawal of the instant petition shall not preclude the petitioner to avail remedies or filing an appropriate application for recalling of the order dated. Only one order, not the other one.
Other one also, your lordship.
No.
Lordship, we have paid till his,
2025.
lordship, kindly.
Absolutely no.
No, lordship, this retirement cannot be. Your lordship, we had submitted reply.
Did I
that
say the permission sought is rejected?
kindly hear.
Permission sought is rejected.
We have paid till his dismissal, your lordship. He has asked for his retirement. That cannot be, your lordship. We have
The
paid his
order dated 10
10, 12,
12,
24.
2024.
That also
as
we-
well as 2012,
Of life.
2025. Taking into account the said submission, the petition stands closed or withdrawn. The petitioner would be at liberty to apply for review of the orders dated 10/12/2024 and 22/2025. Within the corners of a procedural review and not a statutory review. As per the judgment of the Supreme Court in the case of ANZ Gurgulet Bank versus so-and-so, reported in AIR 1983 Supreme Court in so-and-so. The interim order passed earlier stands vacated. The parties being duly represented, they are directed to appear before the learned tribunal on during vacations, 8th of July 2026.
They appeared on behalf of this one number four as legal. As legal.
It will then letters of
Not I pray for some time.
6th of 8th of July.
Good morning, I have mentioned.
Yes.
During our names.
What is our case? What order has been passed? Yes, what is your case?
Okay. In this case, message asked to the petitioner to establish legal locus because the petitioner has not participated. Respondent has issued the tender lordship and accordingly the.
Who is the respondent?
APTC.
APDCL.
Yes.
Who are you?
Lordship, I am for the department. Corporation. We are for the department.
Who has issued the tender?
We-
You have issued the
Yes,
tender,
tender.
not APDCL.
No. Assam Printers Development, APTDCL.
APDCL, they have done it.
They have issued the tender lordship and accordingly, the four tender bidders has participated and thereafter the work order was issued. They have, provided lordship with the.
And what is the case of the petitioner?
The petitioners, they have to establish their locus because the petitioner has not participated.
What is the ground on which the petition was filed?
Or affidavit lordship.
Huh?
In our affidavit lordship,
No, you don't know what is stated out there in the facts.
they are contents.
And
of
who
the-
are you? Mister, who are you?
We are actually sponsoring their this project plan. That's the school for civil and children matter. And we have constructed Assam Development Corporation to build and construct a They're all,
You are the Assam, you are the who? Government of Assam Tribal Affairs.
Yes. I'm for three and
You
three
have
to six.
given the contract, you have entrusted the Assam Plain Tribes Development Corporation Limited to float a tender. Okay, now what is the tender floated?
Tender floated, Lordship, and accordingly the.
On 23/12/2024 was published in so and so for what purpose? For construction of Ekalabba Model Residential School, so and so construction for balance work. And in the same letter, the work of the value of the construction is so and so, the earnest money is so and so is the money, the earnest money, so shown as rupees so and so. I have downloaded the so and so and the tender and did not accept 1% of the tender value or 2% of the tender value. And as a result, the bidder could not be uploaded in the tender portal by the petitioner. That is the only ground.
Yes, only ground. Lordship, may kindly peruse the page 27. Page 27 of the requisition.
Yes.
In notice, one, surplus F rows.
Huh?
One, F, Lordship, earnest money with security to be deposited.
Always feel like for general contractors and so. What?
It is clearly stated, Lordship,
For general, you are having more, less, and SC/ST more.
yes, Lordship, there is some differences, Lordship, but it is clearly stated.
This is absolutely not permissible.
But Lordship,
I've never heard this type of things. Normally, general pays more. Here, you are penalizing the reserve category because they are reserve category. Then, anyway, tell me, they are general.
and Lordship,
They have been penalized.
the below, Lordship, pre-bid meeting was fixed, Lordship, on 5/1/2025. If any confusion was there, Lordship, they may approach the respondent authority because the pre-bid meeting was fixed. 4 bidders has participated. In spite of that, Lordship, 4 bidders has participated, and accordingly, the tender was allotted to the respondent, private respondent.
Now, my question is simple. The bid was done online. Their bid was not accepted only on the ground that they were trying to upload the security, the earnest money deposit, but they could not give it. Therefore, they have uploaded. Okay. They could not file the online bid. Now, my question is, when they tried at that point of time, could the other 4 bidders submit?
Yes, Lordship. That's our case now. 4 bidders participated, Lordship. They submitted. And Lordship, the requisition was filed, work order was issued on 30/1/2025, and this requisition was filed on 11/2/2020.
30?
Issuance of the work order on 30/01/2025 to the respondent over 8. And requisition was filed 11/2/2025. Before that, no, they have not approached the respondent authority regarding their grievance.
And when did you open the technical bid?
Technical bid, Lordship.
Last date was 30/12. Did they submit any representation? Technical bid opening is 10/1/2024. And next,
Work order was issued on 31/2025.
then, and they filed the requisition 11/2.
11/2.
And what is the other requisition for?
Subsequently, work order was sent because we have taken this down.
Okay. You are not preparing.
This is
And
part
appears
10.
on behalf of the petitioner on court. Mr. K. Kolita appears.
So respond 3 to 6.
Mr. K. appears for respondent. Let me give. The arraying of the parties are similar. Huh? In both the requisitions, are they similar? What is your name? You are there in this petition 732. And what about 323?
Lordship, in respect to item number 35, respondent 7. They were not sent.
Why you are not there when the work order has been challenged? No, I'm not on that. Why in 3234 you are there? It's a different thing. No, I was saying as to whether the hearing of the parties is same. 1 to 8 is same here and both the requisitions are same or not.
732, Lordship, they have added two private testimony because one
And the
only
other one?
promo and in respect to
And
other.
the other one, it is 7. You mentioned the matter. Then why you're not ready? You're still looking into the file. You are not ready. Same, it's same.
In one case, there is two private testimony, 7 and 8.
Mr. M.K. Bora appears before this court and submits that he no longer holds the brief for the petitioner in both the petitions. Because Mr. Mr. Arthur appears on behalf of the respondent numbers 1 and 2 in both the petitions. Mr. Kegulta appears on behalf of the Assam Clean Sites Development Corporation Limited, along with its functioning in both the petitions. And the private respondent number 8 is being represented by Mr. K.P. Pathak, the learned counsel. A notice inviting tender was issued by the respondent number 3 on 23/12/2024. For construction of Ekalabya Model Residential School, bracket EMRS, bracket close, Bedlang Mari, District Kokrajhar, under Article 275(1), Constitution of India, bracket for balance work. The value of the work was rupees 6 crores 78 lakhs 21,916. The said notice inviting tender, e-tender, was published on 30/12/2024. And the pre-bid meeting was fixed on 5/1/2025. The online bid submission was on 10/1/2000. You can't help it with this.
10/1/2024.
It has been wrongly mentioned in Annex A. That's copy.
Okay, page 191, power application.
Where?
Right answer.
Bid submission end date was on 10/1/2025. Now, the bid submission start date was on 2/1/2025. And the bid submission end date was on 10/1/2025. It is the case of the petitioners herein, of the petitioner firm herein, that the petitioner firm was interested in participating in the state tender. And as such, took steps for the purpose of submitting that the petitioner firm, the petitioners were interested in submitting the tender and therefore took steps for submitting the tender in the name of the petitioner number 1. However, the petitioner could not upload the bid documents in the tender portal. However, subsequently, the petitioner came to learn that the respondent herein, the respondent number 8 herein, however, the petitioner came to learn that the respondent number 7 and 8 to the petition had quoted rupees 11 lakhs 75,000, 11 crores 75 lakhs 56,408 and rupees 11 lakhs 51,000, 11 crores 51 lakhs 10,557, which was almost 100% higher than the estimated rate of the tender. The petitioners further allege that the ENIT was tailor-made to suit the respondent number 7 and 8. In as much as the period stipulated for submission of the bid was also not as per the settled principles. It is under such circumstances the petitioner had approached this court by filing the writ petition being WPC number 732/2025 on 10/2/2025. The record reveals that on 11/2/2025, this court taking note of the submissions made, and upon hearing only the respondent number 1 and 2 passed an order that the tender process shall remain stay and no work order shall be issued without the leave of the court. Subsequent thereto, the respondents, including the private respondent number 8, appeared and submitted before this court that a work order was already issued on 31/2025. Be that as it may, the interim order which was passed earlier was continued from time to time. The petitioner thereupon filed the second writ petition, being WPC number 3234/2025. Challenging the work order which was issued in favor of the respondent number 8, as well as the bid evaluation committee meeting held on 29/11/2025. The records reveal that in the meantime, the respondent number 326 had filed their affidavit in opposition. Wherein it is mentioned that told the L1 bidder had submitted the bid amount of rupees 11 crores 51 lakhs 10,577.20, which was much higher than the sanctioned amount. But upon negotiation, the L1 bidder restricted the price to rupees 6 crores 78 lakhs 21,916. It was further mentioned the 4 bidders has participated. However, only 2 bidders were technically competent. The letter of acceptance, which was issued to the respondent number 8, which is the subject matter of challenge in WPC number 3234/2025, have been enclosed, wherein it is seen that the value of the work is rupees 6 crores 78 lakhs 21,916. The petitioner, pursuant to the said affidavit in opposition filed by the respondent number 326, has filed a reply. Wherein the petitioner questioned on the issue of a higher earnest money being imposed upon SC/STs for the reserve category, whereas for general category, the earnest money was less. Petitioner also alleged that only 11 days time was granted for submission of the bid. And further referred to various clauses which shows that the tender was not in accordance with the tender was not in fairness, was not fair. The actions on the part of the respondents cannot be said to be fair and reasonable. It is very interesting to take note of. Annexure A to the affidavit in reply and it is really surprising to note that on the same date, 4 bids were issued. 4 bids were the press notice inviting tender was issued for 4 works, which includes 4 works issued by the Managing Director of the Assam Plain Development Corporation Limited, which includes one work which is the subject matter of the present writ petition. Insofar as the present work is question, which is of a much, much higher value. Which is of much higher value than the other three works. The last date for submission of the bid submission is on 10/1/2025, whereas the contract works which are of lesser value, the last date for submission of bid was on 20/1/2025. Mr. Ardor, it is not so good. I don't feel this to be good. Whether he appears or not, that's a different thing, but it's my duty. He did. You quote 11 crores and come back to 6 crores. Negotiation. Is it heard of? I've never heard of people quoting half. All other tenders, which is 50 lakhs and 53 lakhs, you give time for 20 days. But in the case of this present tender, you give 11 days, which is of 6 crores. Whatever may be, it appears to be in good spirit. This is for balance work. Whatever may be. First of all, have you heard of, you have been appearing for oil all this while. 11 crores coming to 6 crores. Negotiation. Only 2 are there who are there because you had to have it, because 2, if it is not there, you have to go for a fresh tender. This particular person, he, if you see there, he did not submit even the 3 years turnover, but he is held to be good. Others are so bad that they didn't submit anything. See this. Kindly see this, Annexure 5, page 196. Look at this. Annual turnover. Normally it has to be given for 3 years. The person number 8 has only given 1. Them so and so insufficient. But he has been held to be technically competent. This is high time. We can't allow this type of things. After all, public interest is huge. And they are willing to pay you again. But do it fairly. Because the work is required to done. We remove the stay. We set aside this tender, and more particularly, why? This caught my attention. Kindly come to page 27. There the problem I see. This is the notice inviting tender which you have published. See the last date for submission. 10/1/2024. Did you issue a corrigendum? No. It is never heard of that the earnest money for SC/ST will be more. have you ever heard of, if this matter goes by any way to the parliament, people will debate that you have in Assam a contract wherein the SC/STs will have to pay more earnest money than the general category. And I can't be a party to this thing. I have to set aside. Petition allowed.
In respect to our three contention, our.
Forget about your contentions. This is absolutely, and we impose a cost upon you.
We record our reply in paragraph 16 and 17
What is that?
regarding the three allegations, only our reply.
What is your allegation
In
reply?
respect of EMD variation, was a paragraph 17(1).
What do you say?
The variation in the earnest money deposit mentioned at different places in the NIT and bid documents was a minor clerical difference.
Minor clerical.
So only.
Because if it is minor, that person has paid how much? Because the petitioner will have to pay 13 into lakhs. One. And if it is a minor, later on you are changing the ball game. You can't do that. That needs to be. Secondly, what is the second contention?
Second contention regarding the SOR variation of the schedule of rates provided in the NIT is based on SOR of the 2013 and 14. And regarding third, is a financial acceptance, we are showing a price quota 100%.
What?
Regarding the third allegation is there, which is almost 100% higher than the estimated pay.
No.
That is, we have stated already payment that is negotiated to the 6%.
Allow it. Whether he is not appearing, but you go for a question. Huh? Yes, your EMD will be released. This type of things, my goodness. Are you appearing? Apply. The petitions allowed.
Yeah, I paid some time for filing my.
Issue notice to the respondent returnable by phone. Communication. Yeah, what do you want? Time. Okay, how much?
3 weeks more.
There's no interim order?
No matter.
You can't delay it so much. Just a simple case of.
He was
No,
convicted.
okay, but if he doesn't have the license, he's a porter.
Yes, my lord.
How will he survive?
Lordship, it cannot be renewed, Lordship, because of the circular, that circular, I don't know.
Understood. If it cannot be renewed by, why you are cancelling it?
Because he was convicted.
Convicted.
Yes.
My lord, the conviction, yes, it is in a.
Oh, this one, guilty.
Yes, pleaded guilty because he didn't want to pursue, because he didn't have money to go under trial.
Yes.
But my lord, among all the other facts and submissions we have given, but the section they have imposed upon him also is not relevant to the
There's
entire
nothing to do
incident.
with moral turpitude. 2,000, imposing a fine of 2,000. And 15 days in connection with so and so. Simple imprisonment. Where's the offense? Anyways, we. 384, extortion. What is 384?
384 is extortion, my lord.
Oh, asking money more.
Go. Give us seat in the court. But it is immediately after the vacation.
Now. This matter again on 22nd of July 2026. On which date an attempt shall be made to dispose of the petition. A final opportunity is being granted to the respondents to bring on record their stand by filing the affidavits on or before 27/2020.
My lord, there is an additional where our names have not been reflected in the wakalat, in the cause list. There's only one, council's name has been reflected. Whereas there are four, it will be reflected.
You go to the registry. What do you want? Did you get it? You got the, even this. Don't do silent for you. These are the other two agreements, no? Both have 8.9.
Yes.
Because then I mentioned the dates and all. Will be better.
Wait for myself.
Even though, yeah, going for on X and Y make.
Forest may dispose of this case now.
Huh?
Matter relates to payment of admitted amount.
How much?
36,90,980.
You want the expert term said?
No,
You dispute the contract?
Lordship, the contract ultimately, Lordship, closed, Lordship. Whatever work he has done, Lordship, will have to.
My question is, do you dispute the contract? No.
No,
You dispute the amount.
no. They admit it, Lordship.
You admit the
They
amount.
admit it.
So then you pay as per terms early.
Next, Lordship.
The amount is how much?
36
36 lakhs.
90,980.
But do you have anything on record?
Lordship.
Otherwise, tomorrow we may have a difficulties. What did it without any?
Today, demand will be submitted for data. The instruction is.
Chief engineer has given, na?
Lordship.
Manoranjan Burma. How much do you know? They are stated in
Paragraph three, paragraph three.
prepared for fees none by the extended months and so. But where is the admission?
With the paragraph 3, the reply, Lordship. They have already submitted a demand, Lordship. So this is the admission by the executive engineer, so the chief engineer will verify, Lordship. As per council earlier.
So you will verify and pay.
Yes, Lordship.
Verify within 1 month.
Lordship.
Pay within as per terms.
Lordship.
Time limit. Irrigation, huh? Exclusion.
Can a time limit be fixed for payment subject to verify?
What?
Time limit be fixed for payment?
How? I therefore say 1 month verification, then to pay as per terms.
Loss. Obliged.
Develop. If you are putting higher than this, you will get in.
Lordship, senior counsel, as Dr. Madam, he's on breaks, madam. Can we have it after some time?
Huh?
Madam, senior counsel, my lord, as Dr. Madam,
Where is he?
he's on lakes, madam. His
Huh?
item is going on, so after some time, my lord.
No,
Or the
after
last
some
time,
time.
or the
You
next week, any day.
Anyways, we'll have it on some other day. When do you want it? After vacation? Let us have it after, because we don't have time now. Any interim order pass?
No, no.
of July or 27th.
This is pertaining to that, one,
Two parts,
one
my lord.
portion, na?
Cancellation and the holiday listing.
Okay, okay, I remember that, okay. List this matter. Clearings being complete, list this matter for final disposal on 28th of July 2020. What non-payment?
Yes, sir.
In
Lordship.
on non-payment lordship, in one case I have received the instruction lordship. But the lordship, the
petition number, probably they have mistakenly written the petition number. Otherwise, they have the second writ petition amount they have admitted also. Writ petition 586725 Losik, they have said that the claim is in order loss. In the 5867, their claim is loss is 3,66,086.
No, 2,25,000.
5867.
5867 loss is 3,66,086.
No, 2 lakh.
প্রথম বলে আমার একটু ভুল হয়েছে।
2 lakh, it is rightly.
Then
2
loss
lakh
our petition it is loss.
No, they have given.
They
it.
have lost.
Mr. Devi has.
Even the service copy
Where
they
the
have.
proposal has been given. Okay,
Service-
this we put it as Excel deposit of this one. The other one,
Other one, I have not received instruction. Other one, I have not received instruction.
okay, other one to be listed after vacation in the meantime, the instructions will.
I will provide him the copy, Your Lordship. I will provide him the copy.
Yes, well,
Other one to be এখন আমার পুলিশ হয় একশো কাজ অন্য নদীটো হ'ল এখন কন্টেন্ট কৰিলো আৰু এইখনত হ'ল 5985 this Mr. K. Gowoi, the learned additional senior government advocate submits that he yet to receive instructions in the matter. Considering the above listed matter on 27th of July 2026. The council's, the learned, the respondent authority shall provide due instructions as to whether the petitioner is entitled to the amount as claimed. 672
Sir, we applied for registration under the Provident Fund, my lord. Plans for Provident Fund, they have not registered, my lord. Earlier, my lord, it was given on leave, we have not applied. Now we are running ourselves, so we have applied.
They filed an affidavit.
Affidavit, my lord, they said that earlier it was leased out to somebody else. But at that time, we have not
You
applied.
don't want to file reply?
Not necessary, my lord. Because we are now running, my lord, and we are applied, they will get, my lord, that Provident Fund. We shall deposit it. The employer contribution.
Hello, you'll have it. Let us have it after vacation. Urgency, no urgency.
Well, registration is necessary, my lord, because you cannot deposit the Provident Fund otherwise. The employees are, my lord, suffering, my lord. There is no reason for not registering us.
Okay, list the matter on 18th of June 2026. On which date an attempt shall be made to dispose of.
Made to the motion. When we challenge the tender document on the point that there are two grounds taken in tender issues, whether that I could not have been blacklisted earlier. And number one, in regard to proprietorship, they insisted me on having registration under the Companies Act. That's at page 22. My lord, by taking up the matter, was pleased to state the further evaluation. Page 22, point numbers 1 and 7.
Oh, that one.
Yes, lordship. It's under stay because others can participate on that count. The tender process is stayed on the count that if lordship interferes, then other parties can also participate. Solely on that, what they have to say. They have not spoken much in the affidavit though.
So we therefore set aside, if we set aside these clauses 1 to 7, then it has to go for a written.
Written.
What is your stand?
Lordship, in the affidavit, we have stated regarding only the point number 7, Lordship. But regarding point number 1, the pre-criteria at page 22, that is the bidder pre-qualification criteria. That, my lord, in that, my lord, the Lordship comes to page 22. Bidder must be a company / firm / proprietorship incorporated under the Indian Companies Act 1956
or a firm registered under the Indian Limited Liability Partnership Act 2008. And in this case, my lord, if your lordship sees, he's a proprietor, sole proprietor. So whether that part, my lord, whether he can apply because he does not fulfill the criteria.
Why do you want an LLP? Not
Well,
a
that,
proprietor? You don't trust proprietor.
The
You
department.
cannot have a wisdom of the author to be such that they will have whatever cause.
They have
They
insisted
will
for a proprietor.
violation of Article 14.
It's the other way around. They have insisted for a proprietor, but a requirement in a rider that I must have a registration under the Companies Act or the other act, which I cannot fulfill anymore. That's my case.
That is also the.
Clause 1 and submitted that though the bidder can be a company so and so, the respondent in the said clause required a documentary proof of registration under so and so or registered under the Indian Act. So and so the lender submitted that the proprietor cannot be registered under either. So that clause is self-defeating.
And my lord, regarding the at page 21, my lord, regarding if a lordship comes to page turns to page 21, further if a lordship comes below the clause 16, there is a this thing, my lord, paragraph at the ending of the bid document, that is at page 21. Further, if any seller has any objection, grievance slash grievance against these additional clauses or otherwise on any aspect of this bid, they can raise their representation against the same by using the representation window provided in the details.
No.
So there, my lord, he has given a
All these things after the matter has been pending from 2025 doesn't make sense.
And my
We'll
lord,
go as per the first clause is bad. What is 7? The clauses submitted at any.
7, my lord, I agree, my lord.
Blacklisted or debarred and
That I agree, my lord.
also at any point of time. So therefore, this is also bad because it goes against the very
Exactly. That I
principle
agree.
that you cannot debar them for all times to come. It is
My
bad.
lord,
Anyways, we don't have time to.
we can do that.
We don't see Mr. Esbonic because I don't have fisheries. I think after 1/7/2027 fisheries will come in, then we may see Mr. Bonic. Otherwise, fishery master is. Anyway, let us again see his book. We have it before vacation or after vacation.
Leave it to your lordship.
You have no urgency.
My lord can have it before vacation.
You don't have urgency because you filed the affidavit after long.
No, my lord. What happened was, my lord, I was the other Vidyalaya didn't have a council. So recently, my lord, Mr. SMDC and I have been appointed.
See, next week is the only time. Then the next week is. But this won't take time.
Exactly.
Okay, with the matter on 25th of June 2026,
Right.
on which date an attempt shall be made to the school.
The interim order may continue.
Interim order passed the list.
Deeply.
Management of archaeologically and no files.
Well, basic issue is the reference was made by the.
We are representing. Both of you are, all parties are represented. So records have,
Records have just come. Yes.
Okay. So we fix it for final disposal on 11th of August. Well, taking into account that the records are available and the issue involved in the instant proceedings pertains to a labor dispute. Labor,
Industrial dispute.
Industrial dispute.
termination.
Termination and retractment.
It's an industrial dispute. This court fixes the present proceedings for final disposal on 13th of August 2025. Is it in time order, na?
No.
In the August. For final dispute.
In this case, my lord, respondent has filed affidavit yesterday. Filed a response.
Reply?
Yes, ma'am.
They've been submitted, which respondent?
Seven number 7 has filed, 7.
And government?
Respondent number 7 has filed.
Government?
Government is not filed.
Government is required, na?
My lord, the government affidavit is this.
What is second do? Which department? Deputy, the food,
My lord, food and civil supply department.
food and civil supply.
Deputy Commissioner will file it.
The respondent numbers, official respondent more particularly. Mr. K. Gogoi appearing on behalf of the respondent numbers 1, 2, 3, 4, 5, 6, 5 submits that some time may be granted for filing the affidavit. This matter again on 31st of July 2026. In the meantime, the affidavit be on behalf of the state be filed on or before 29th of July 2026.
May I please, your lordship? My lord, I am appearing on behalf of respondent number 5. My lord, I file my objection.
You filed?
Not file.
You will file.
Yes, I will file.
You have been selected.
Yes, my lord, already running. My petrol pump is running. Okay.
Mr. So-and-so who appears on behalf of the respondent number 5 submits that some time may be granted for filing the affidavit in opposition. List this matter on 14th of August 2026. In the meantime, the affidavit in opposition be filed on or before 3rd of August 2026. Liberty given to the petitioner in the meantime to file reply against the affidavit in opposition filed by the respondent number 4 as well as the respondent number 5 on or before the next date. You have not filed. Who is filed? Respondent number 4. Who is this?
Respondent number 4.
Respondent number 4.
You have filed. Okay, you have not filed. You also filed. 1, 2, 3.
1 and 2.
1 and 2 and respond number 5 submits that they let them file by 3rd of August. In the meantime, petitioner liberty to file replies against the affidavit filed by the respondent number 4 as well as the other respondents on or before the next. Yeah.
Obligement.
Non-payment. You got anything? Police.
Also, paragraph 4. Paragraph 4, our affidavit.
Paragraph 4.
Page 30, lordship.
Paragraph 4.
So,
Paragraph
paragraph 5. Page 30, paragraph 5.
Proposal has been sent. How much fee? Total?
Total lordship 9,28,340 lordship.
Next
Total
item.
9 lakh. Huh? Police also. 4.
Paragraph 5, my lord.
I will give. 9,28,000. If I took it for this case. Post. Affidavit filed.
Yesterday, affidavit filed also.
Lordship, I appear on behalf of respondent number 5. I have filed my affidavit in opposition on 12/5/26, to which the petitioner has filed reply
How?
today.
You filed on 12/5.
Yes.
Okay.
Respondent number 5, you will file. I have filed reply today, you will say. Yesterday, you will see respondent number 2 to 5, 2 to file Philippine opposition.
You also filed.
Yes,
reply.
yesterday file you also. I need 10 days time to file reply.
You want to file reply. The council, the respondents have already, all the respondents have filed, na?
Lordship.
So I am appearing for 2, 3 and 4. We have filed our report.
Yesterday they have filed.
Yesterday.
You have filed. And you have filed.
Yes, I have filed on behalf of respondent number 5.
The respondent number 2, 3, 4, and 5 have already filed their affidavit in opposition. The council appearing on behalf of the petitioner 6 time for filing reply. Considering that there is an interim order. Where is the interim order?
status quo is given.
Interim order, comma. List this matter on 12th of August 2025, 26. In the meantime, replies be filed on or before 5th of August 2026.
There is an urgency or that is because my establishment is closed.
It's closed. Is the status quo. Okay, we have it after vacation. On 15th of July 2026. In the meantime, you file your reply by 13th July.
Obliged,
Interim order
Lordship.
passed earlier shall continue till the next meeting.
Deeply obliged.
Yes, why this matter is here? Anything happen?
Lordship. The release order has been passed.
Oh, there's nothing.
No, my lord, after the direction of my lordship, your lordship, release order has been passed. Now they are not releasing the vehicle. They are not accepting the challan. For that also, I think a direction will be needed. In 15 days, my.
You have submitted the bond.
No, they are not providing the challan for the security deposit, your lordship.
Huh?
They are not providing the challan, your lordship.
You have to give 4,90,000.
40.
49,50,000 of the.
No, 10% of the value.
So, my lord.
4,95,000.
My lord, I'm ready for that, but they are asking me to, earlier on 25th, order was, it was released, my lord. Thereafter 2 days, I was been called. Thereafter, they are now saying come after 1 week. That is what.
You are ready?
I'm ready. So direction may be given on.
We do one thing.
Lordship. Yes.
Mr. KJ in the learned counsel appearing in pursuance to the order passed by this court on 22/5/2025. An order has been passed by a provisional release order has been passed by the superintendent bracket ADJ bracket close customs bracket P division Karimganj. Whereby the vehicle of the petitioner have been provisionally thought to be released subject to submission, subject to 3 conditions. That is, number 1, execution of a proper notarized bond for full seizure value of the goods, that is rupees 3,36,46,064. Number 2, payment of security deposit of rupees 10% of the value of the vehicle, that is rupees 49,50,000. And number 3, proper identification of the ownership of the vehicle. The said provisional release order is kept on record and marked with the letter X. Ms. S.S. Jia, the learned counsel appearing on behalf of the petitioner, submits that the petitioner is ready to submit the documents, as sought for in the provisional release order. The learned counsel further submits that the said petitioner shall do so within, give me a date. Can you do it by 19th?
What?
By 19th of June 2026. It is observed and directed that upon the petitioner complying with the 3 conditions mentioned in the provisional release order, the vehicle of the petitioner be released. An update in that regard be placed before this court on 24th of June 2026. I hope this will do, madam.
Item number 39 also. Can I have it on 24th also?
Which is
I have-
item
I
number?
have taken. And, And the Lordship has given 28,
What does he want?
24,
You want 22,
24.
24? Okay.
Equal. July.
July, na?
July.